left her Next week.
My lords, fresh matter, my lords. The land,
Yes, brother.
My lords, the land grabbing court has posted my matter for framing of charge. I'm an accused in the land grabbing court, my lords.
Yavatide adu?
My lords, 6th of next month, my lords, during the
6th of
vacation.
May.
Please, my lords, it will be taken up on Monday, my lords. We have challenged the entire proceeding.
31st, 28th.
28. Could I request Monday, my lords? Please.
Yes, sir.
Your Honor, for WP 24623 of 24, it was to be listed this week. Today is the last day of the week. It is not on the cause list.
Therefore, not possible.
I have filed a response to the objections filed by the respondent 3.
It will come immediately after vacation. One memo kodi, or one paper kodi.
I would move a memo. If you give me a date after the vacation, yours.
Ado memo kotrane mundu kodabodu.
If you give me a date, I'll put the.
I cannot give date for obvious reasons. You can ask your lawyer friends.
Okay.
Therefore, we cannot give date.
Your Honor, WN 983 is posted for 22nd for orders. May I move the memo after that?
All.
Okay.
Okay. Yes.
My lord.
Yes, Mr.
Serial number 27, my lord.
27.
Yes. Kindly wait on Monday, my lord. Senior is out of station. Yes.
Mukanappa.
Yes.
After vacation.
Monday.
Okay. After vacation. Yes.
But
Aden illa adralli, but anyway, you take chance before other judges. Yes. Yes, learned DG has come. Junior training officers.
Please, it may come after vacation.
After vacation.
After.
That's good. Because of obvious developments that have taken place na, in the recent past. After vacation agli. Right? Yes. After vacation and tanana.
Just agenda and tell
Aste. Call after vacation at the request of learned DG appearing for the state. Yes. Two.
My lord, I appear for the petitioner. Lord, in this matter, respondent number 3, my lord, is represented by the state. So state government may be asked to take notice for respondent number 3.
R3.
Lord, R3 is the.
Accountant General, please, learned DG is requested to accept notice for respondent number 3. Now, the copy could.
Please.
Okay. Next.
Great.
Call after vacation. Anil Kumar.
Appear for petition, my lord. Today we have received a new address, my lord.
You got it, new address you have got now?
Yes, my lord.
Steps within 1 week, failing
Please,
this
madam.
petition stands rejected. Yes.
I'm appearing for petitioner.
Ha.
My lord, so pleased to call for the entire records before the committee.
Yes.
It is yet to, my lord, to be
They're ready to
received.
come now. Anyway, after vacation.
Please.
Yes. Baburao.
Translation on the objection ಅಷ್ಟೇ.
ಅಷ್ಟೇ ಇದೆಯಾ? All right. But translation ಬೇಕಾಗಬಹುದು after vacation. All translation dispensed with for the time being.
And matter pertains to time bound and promotion. Time bound ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. And KT said that it is
ಬರ್ಕೊಳ್ಳಿ. Notice ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
Issue notice, learned DG is requested to accept notice for respondent. Respondents, okay. Next.
Oblige.
6. Siri.
Teacher C&R statement together, SLC and diploma, they must secure 50%. And we have written KPS.
All
Yes, KPS. I read the impugned order.
Yes, in
But second petition, Anil Kumar Lavina, first other case I 21st attempt, 6 of 2020. Please act.
in the contempt proceedings in
6 of 2025. 6 of
yes. All Kannada lectures to be produced.
Translation
Translation not necessary. Dispensed it.
and notice are this.
ಏನಿದು ಮ್ಯಾಟರ್?
Departmental inquiry, the petitioner for being not initiated the inquiry against the contractor. Of 4 increments with cumulative effect imposed.
ಏನಿಲ್ಲ ಇದ್ರಲ್ಲಿ ನೋಡ್ದೆ ನಾನು. ಏನಿಲ್ಲ ಕೇಸ್ ಫಾರ್ ಡಿಸ್ಮಿಸಲ್ ಟೇಕ್ ಚಾನ್ಸ್ ಬಿಫೋರ್ ಅದರ್ ಜಡ್ಜ್
ಅಲ್ಲ, ಈ ಒಳಗೆ ನೋಟಿಸ್
issue notice. AG is requested to accept notice for the respondents. One. ಮತ್ತೆ ಬೇರೆ ಯಾರಿದ್ದಾರೆ? Anthony Joseph for all.
Oblast.
20. Yes.
Appearing for
Yes,
the
question.
office objection is, my lord, the translated copies, my lord.
Dispensed it.
Kind lords, matter pertains to recruitment to the post of assistant professor, my lord.
Assistant professor.
Yes.
ಏನದು?
I am for the respondent. I pray for time, my lordship.
You pray for time.
Yeah, my.
Yes. Call after vacation at the request. Notice ಆಗಿಲ್ಲ.
Kindly one submission.
Ah.
During the course of before the tribunal, my lord, the appointments of the private respondents.
Yes.
It's subject to result of the application. Here issues, my lord, requires consideration because, my lord, the KCS Act, my lord, describes how to amend the CNR rules, my lord. That procedure, my lord, is ignored, and, my lord, by way of an executive order, my lord, the CNR rules have been amended.
Earlier under 309 ಇತ್ತು, ಈಗ 1978 ಆಕ್ಟ್ ಕೆಳಗೆ ಮಾಡಬೇಕಾಗ್ತದೆ. ಅಲ್ಲಿ ಪ್ರೊಸೀಜರ್ ಇದೆ.
ಹೌದು.
That procedure is not followed.
Not followed. That only based on that, my lord, the one of the member of the honorable member of the tribunal has taken view and allowed the application, and the judicial member has taken different view. Matter went before the
Requires consideration.
yes,
Issue notice. Learned ನೋಡಿ ಯಾರ್ಯಾರು? ಹಾ. Emergent notice. All right.
will take hand summons, my lord, to
In
respond.
addition to taking usual steps, a petitioner is permitted to take hand summons as well.
And,
Okay.
and the my lord, subject to result of the writ petition
ಏನು?
of their appointments. private-
ಆಗಿದಾವ ಈಗ?
Already they are issued.
ಆಗಿದ್ದನ್ನು ನಾವು ಈಗ ಹೆಂಗ್ ಮಾಡೋದು?
Before the tribunal, it was there, my lord, the same order. Their appointments are subject to result of the.
Petitioner is entitled to argue the doctrine of lis pendens in respect of appointments already made or to be made. Okay.
Obliged.
May I please, my lords? My lords, your lordships may not even open the files, my lords. First, there's an office objection, my lord, saying that there's an appeal provision. Why are you in a writ? I'll make good the case, my lords. There is a provisional attachment against.
That's all right. We will not hear you. Why are you not coming to Karnataka High Court? Where our youngsters should go to learn so many things. There are many other advocates are also there. But unless the lawyers of your stature come and argue, how youngsters should learn?
I plead guilty to it, my lords. I'll amend. I'll amend. I'll amend, my lords.
That's
My
important.
heart is here, my lords. Unfortunately, I moved to.
No, but only heart is not sufficient.
Correct. My wife says that too, my lords.
Yes.
My lords, without the papers, I'll just, my lords,
Very well,
in
very
2
well.
minutes.
Yes.
There's a provisional attachment order against me on the basis that I am Jindal, my lords, that I have taken iron ore from a company which is involved, my lords, in whatever illegality. I owe money to that company. Therefore, the money that is available with me, the money that's available with me should be attached. That's a provisional attachment order.
Money should be attached.
Yes, money which is available with me should be attached because that money belongs to the iron ore company whose produce has been given to me, my lords. That was the ground on which the PO is issued. My lords, in the adjudication proceedings for confirmation of the provisional attachment, I filed before the authority an arbitral award prior to the date of the provisional order, which indicates that in our interstate dispute, I owe no money to that mining company. Quite to the contrary, mining company owes money to me.
There is an award.
There is an award in my favor. A 34 is filed. 34 is not interfered. Award, my lords, by a former Chief Justice of a High Court, my lords, in Bombay, sitting on and deciding the matter. 34 is filed by that mining company.
They say you do not owe. No, they owe to you.
Because my lords, the money that I have paid them, to that extent supplies are not made, therefore they should now return the money, because the supplies, further supplies can't be made because they are tainted, my lords, by illegality. Money should come to me. I filed 3 more filings, my lords, before the adjudicating authority. Adjudicating authority, my lords, refuses to consider any one of this on the basis that under section 8 you have to file a reply. You cannot file any other pleadings other than a reply. You have not filed a reply, therefore I will not consider it. In fact, 8.3 says my reply and any other material available. That any other material, my lords, was for pleadings. I bring that in appeal, my lords, to the PMLAT. PMLAT, my lords, I raise one point saying principles of natural justice must first be meted out to me in the adjudicating authority. Principles of natural justice in appeal does not cure principles of natural justice in the first instance.
That other day you said, but I read in a Jain and Jain administrative law and IP Messi also, after hearing you. Both they say, they have quoted some decision. The violation of principles of natural justice at the threshold can be made good in appellate stage and the hold madidanta rulings oddena.
That's 2 submissions on that, my lords, apart of the merits. My lords, the traditional knowledge of wisdom of indicating that yes, if principles of natural justice is cured at the appellate stage, then that cures actually any illegality. You have been heard once. My lords, fortunately, my lords, a 3-judge bench of the Supreme Court refuses to accept it on the basis that you are entitled to a good trial and a good appeal. You can't substitute a good appeal and make the error which is in a bad trial, and therefore principles of natural justice at first instance must be meted out. If it is not meted out, you will be sent back to that position. And that's, my lords, Justice Rishikesh Roy's 3-judge bench. Please give the decision. I'll just show 2 paragraphs.
Yes.
And in fact, my lords, I'm carrying coal to Newcastle. Please pardon me for it. In 1986, my lords, there was, my lords, a similar rendition by a 2-judge bench of the Supreme Court. Unfortunately, my lords, it has remained in oblivion. I'll just show those 2 paragraphs, my lords. It is, they use, my lords, I think Lord Megary's reference of indicating that a good appeal does not substitute a bad trial. My lords, please permit me just 1 paragraph. Please see, my lords, in this page number. Krishna Dutt Avasti, my lords, is at page for them in your compilation page number
29.
My lords, it starts, I think, at page 29, my lords. Paragraph number 66 and 67, my lords, are at page 51. Just 1 minute. My lords, please see 66, 67, just 5 lines, my lords. Then I'll trouble your lordships with just one other decision. My lord, this is the judgment in 2025. 3 judges of the Honorable Supreme Court considering this aspect. My lords, would your lordships permit me?
Yeah.
Additionally, a perusal of the orders of the collector and commissioner in revision.
Paragraph.
I'm sorry.
Page.
My lords, bench consisting, my lords, of Justice Rishikesh Roy, the judgment, my lords, of Honorable Justice Rishikesh Roy, page number 29, my lords, and Justice Sudarshan Dulia and Justice Bhatti, but authored, my lords, by Roy.
Yeah.
Justice Roy, my lord, I think just before demitting office, these were the last batch of matters that they considered, my lords.
Yes.
My lords, please permit me to invite my lord to 66 at page number 51.
Page 51.
My lords, I seek leave for reading 66 and 67, my lords.
66, 67.
Please, please. My lords, page numbers are on the top quadrant of the page, my lords. Ink page numbers at 51 on top.
Yes.
If my lord has it. Additionally, a perusal of orders of the commissioner and the commissioner in revision would show that they are practically identical. An ineffective hearing at the initial stage, therefore,
we are not on same page.
Oh, I'm so sorry.
Even as lawyers, we are not on the same page also.
I understand.
51.
My lords, ink page 51 on the very top quadrant, my lords, page numbers are indicated. 5-1, please, my lords.
You are right.
My lords, in 5-1 on the top quadrant of the page.
Yes. Additionally,
my lords, page number para 66 and 67.
Additionally,
yes, please. Additionally, a perusal of the orders of the collector and the commissioner in revision would show that they are practically identical. An ineffective hearing at the initial stage therefore taints the entire decision-making process, leading to a cascade of flawed orders at the subsequent stage. Providing a hearing to the affected individual minimizes the risk of administrative authorities, decision making, etc., as it allows all pertinent issues to be brought to light.
At very first instance itself, they should be fair, last line.
Kindly see, my lords, the last 3 lines, my lords, in that
Correct.
paragraph.
I read.
The primary purpose of natural justice to assist administration, etc., etc., reducing the likelihood of the decision of being overturned later. My lords, it is the significance lies in fostering fair and well-informed decision making at the very first instance. My lords, please permit me to 67, my lords, is to the same scenario. Kindly see, my lords, the one.
How they have treated the contra view?
My lords, unfortunately, that contra view to indicate, my lords, that it cures. I've read the order, my lords, does not say that that is correct or wrong. They, my lords, go on to the essence. Possibly, my lords, drawing reference. They don't draw that reference in as many words. Please see one page, my lords. Please come to, my lords, in this compilation, page number 71 in this very compilation. My lord, this is the decision, my lords, of, I think, Justice Pathak, my lords, 1986. Please come to, my lords, paragraph 17. This was, my lords, in the context.
Urged.
My lords, it is then urged. Please see, my lords, the 2 inundated sub-paragraphs within that 17.
Natural justice is violated.
Yes,
at the
my lords,
first
I'll read,
page.
my lords. I won't trouble my lords to read. If natural justice is violated at first instance, the right of appeal is not so much a true right of appeal as a corrected initial hearing. Instead, a fair trial followed by an appeal. The procedure is reduced to an unfair trial followed by a fair appeal. In the words of Justice Megare, etc., etc., my lords, Megare, the Vice Chancellor of Chancery Division, please come down, my lords. If one accepts the contention that the defect of natural justice in a trial body can be cured by the presence of natural justice in an appellate body, this has to result in depriving a member of the right of appeal from a expelling body. If the rules of the law combine to give a member a right of fair trial and a right of appeal, why should he be told that he ought to be satisfied by an unjust trial and a fair appeal? And here, my lords, the appellate tribunal now says, I can't do piecemeal. You please argue all your points, including this point of natural justice, I will consider. Therefore, my prayer is only, my lords, that I must, at the least, this appellate authority must first consider my submissions on the fact that my natural justice has been violated at the adjudicating authority's instance, because despite material before him, he refuses to see the material, saying this is not in the form of a reply.
Whether the appellate authority has to pass the order in a time-bound way under the statute?
In the statute, my lords, there is confirmation, my lords, that is the confirmation order, my lords, is within 180 days. But that confirmation has occurred here, which I am taking in appeal. This appellate tribunal, my lords, does not have a scenario saying that they should dispose it of. Now, the May, my lords, is the date is, I think, my lords, 20th of May is when the matter is put to. We filed a writ petition because it was put to earlier, but in the light of the fact that we indicated we are before my lords,
Can I look into papers now?
Please, my lords. I'm grateful. I'm so sorry, my lords.
No, no, on law you have taken us, no?
I stand corrected on that appeal stage. Section 26, subsection 6 seems to say that appeal filed before the tribunal, there shall be an endeavor to dispose it off within 6 months.
Within 6 months, not
a timeline.
it is like CPC provision only. Particular that.
That's one fact. I'm sorry.
Appeal to High Court.
No, not appeal to High Court is 42 months. So one fact I must place before my lords, although there is no bearing on my duty. In the very first round, my lords, where the tainted mining company, my lords, was actually supplying to me, there was proceedings by that mining company to quash the ECIR against that mining company. In those proceedings, my lords, 10, 12 years ago, my lords had represented the union, my lords, at that point in time. That has no bearing on me, but I'm bringing that one.
That was more than
Obalipuram and Associated Mining Company, my lords.
OBC man.
This honorable court, my lords, quashed the ECIR on the ground that the predicate offences were amended and brought in the schedule later on.
What happened to that judgment?
My lord, that man traveled to the Supreme Court. Honorable Justice Nariman at that point of time, my lords, indicated that it should be examined, but however did not stay the judgment inter partes, but made an observation that this judgment shall not become a precedent for further question, and therefore, my lords, matter is pending.
So it will not come in my way?
No.
Or you can take chance before some other judge?
No, my lords. My lord, then again, fair hearing, my lords, fair hearing. How can that come in the way, my lords? I am not even predicting, I am bringing it to my lord's notice, my duty.
No, I don't remember. I don't remember also.
I am not even predicating my pleadings on that order. Your lordship may assume that.
Just kindly show us the award.
Yes. Well, I have a list of dates and I've stated a company award. You'll also kindly see page number 97.
No, this is JSW steel, na? What we have to do with that OBC?
No, unless somebody says we didn't bring it to Malad office,
No.
we put it.
Nothing to do.
This JSW has nothing to do with those meetings, whether they stand or they lose. Annexure B Manots at 97 Manots is the award.
97.
Yes, please. I showed just 2 or 3 paragraphs. Manots.
Money is not only due, money is due from the other side.
Manots, what
That,
happened was this, Manots. Fact was this. Company X Manots supplies material to me.
that's true.
And Manots,
No, that money went to, some other person is holding your money. Therefore, we trace it and attach. That is the stand.
That stand is that therefore the money that you owe to that company X is with you. I am proceeding against X, therefore I am provisionally attaching your money. I show an award prior to this attachment which indicates that I don't owe money to X.
But X owes money to you.
X and Y were associated companies. Y owes money to me. I went in an arbitration and the arbitral award is that the money should flow to you and not from you.
Where is that?
Please, 97 is where it starts.
That finding one sentence you can show, Mr. Kuvaiya.
Please come to my notes. 116. I am the claimant here, the award at 116. The respondent is to pay the claimant a principal amount of 35 crores, etc., etc., with interest on October so 2001, etc. And the respondent is to pay the claimant sum of 75 crores, etc., in damages till the final award. This is based, my lords, in 113. The second paragraph, I will just read my lords 112 bottom, please see para 25 minutes. I'll just read that paragraph. I am at 112 para 25.
Yes.
From the evidence produced on record and the issues now answered, this was the Honorable Justice Rebel of the arbitrator. In so far as issue number 1 is concerned, the claimant has proved that the agreement C1 and also has proved that the evidence produced in the form of certificates of the banks, etc., that a sum of 130 crores has been advanced to the respondent, money from me to them. The evidence on record proves that after adjustment for all quantity of ore which the respondent has
Self payable will be 35 crore, 44 lakhs.
should come to me. Now the attachment is some 9.5 crores plus and another second attachment is 33 crores.
Yes. Although they were not parties, that question will not be up.
Doesn't arise. I know not this award was before the adjudicating authority. Not one word in the adjudicating authority's order as to how this award has been treated. The only finding is you have not filed a reply. You should have filed your own reply, and therefore I will proceed. I can show that line. He says you have not filed your reply is the starting of the presumption.
That's what. Sorry. Heard learned senior advocate Mr. Kuvaiya appearing for the petitioner company. First, we have perused the records, more particularly the arbitral award dated
9/5/2014.
9/5/2014, which precedes the initiation of proceedings under the PMLA.
Yes, please.
Initiation of PMLA proceedings.
Which precedes the provisional attachment order.
Which precedes the provisional attachment order.
Dated 27/3/2015.
27/3/2015. First. We also adverted to Apex Court ruling in Krishna Datta in 2025 SEC online
SC 179.
SC 179, which broadly states that violation of principles of natural justice at the initial level of the proceeding cannot be made good in the appellate proceedings, in as much as the very purpose of complying with the principles of natural justice is to make the order or outcome not to be vulnerable for challenge in appeal. Full stop. This principle appears to have been violated in the impugned proceedings. Full stop. That apart, the award shows that not only petitioner's money was not with the associate company, ಯಾವ್ದದು?
It shows that their money was not.
That's what, not that your money is there. No, his money is with you, but your money is with him. ಏನ್ ಬರ್ತದೆ? Award shows that not only the other parties' money was with the petitioner company, but petitioner company's money itself was with the other company. First, next paragraph. In the above circumstances, issue emergent notice and interim order as prayed for till next date of hearing. ಯಾರು ಅಪಿಯರ್ ಆಗೋದು ಇವರಿಗೆ? ಶ್ರೀ ಯಾರು? ಶ್ರೀ ಮಧುಕರ್ ದೇಶಪಾಂಡೆ. Petitioner, in addition to taking usual steps, shall serve a copy of this petition along with all the documents on the panel counsel, Shri Madhukar Deshpande. Issue of maintainability is kept open.
Lords, item 11 is identical. Only the date of the provisional attachment order changes minutes.
That's all.
Same entity.
You don't want OAI to argue that matter, so
No,
that
my
you
lord,
can
I
retain
just-
that. Nothing. That's 11 norms. Same order. Call along with. We'll make them call along with. Yes.
And I will rectify the mistake of not.
No, why I say that is, if we have many tall lawyers here, still the grass on the other side is greener for us. Of course, there is no grass in Delhi is another thing.
So I thought and went,
But-
my lords, I find out.
But you have to keep coming here. And whenever you come, try to address youngsters on advocacy skills, so many things. I think that I saw your Pennsylvania lecture, University of Pennsylvania lecture. I was immensely impressed by that. But why you used papers for delivering the lecture? Person of your stature is not supposed to use the chit at all, but there it is not permitted.
No, my lords, that particular event, my lords, my digital medium didn't really work. Otherwise, my lords, I'm fully digital.
Okay. Because when Amartya Sen was asked to come and give lecture after he was awarded Nobel Prize for idea of justice and such other works, that university, Oxford, perhaps Cambridge, whichever, I do not know, or Oldham University, they said, where are your lecture papers? Amartya Sen said, I don't need lecture papers. But our university tradition is, unless you have lecture papers, you will not be permitted to speak. Then he said, all right, no problem. I have those papers. He kept them in a wrapper. They were all ready papers. And said, I have papers, I will give lecture. Then without looking, turning the pages, he gave lecture for 2 hours. And what all he spoke, people believed that he only read the papers. Thereafter, he had shown, these are my Radhi papers, which I had kept to comply with your rule. Your lecture was great. Nowadays, rarely we find preparation is lacking. And they think that memory has to be brought from some shop. It does not come that way. It comes by practice. The language, especially your argument in Shreya Singhal, such a great argument. I felt so happy. So whenever you come here, you have to gather at least handpick few lawyers, youngsters, ask them to sit with you for 10 minutes, 20 minutes, so that the bar quality, we always learn not by reading at all. Our Indian tradition is not by reading. It is by seeing. Therefore, Guru Shishya Parampara. Shishya will see the Guru. And therefore, they said this Gurukula should be abolished. 1835 resolution by Macaulay. First abolish Gurukuls. Everything will be all right in this country. Therefore, that whenever you come, not only you, but even our lawyers like Service Doyne, Mr. Rajgopal is here. Many are here. They should address our young lawyers who come from ಹಳ್ಳಿಯಿಂದ ಬಂದಿರ್ತಾರೆ. ಅವರಿಗೆಲ್ಲ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ನಮ್ಗೆ ಅಷ್ಟು ಚೆನ್ನಾಗಿ ಭಾಷೆ ಬರಲ್ಲ, ಕಾನೂನಿನ ಜ್ಞಾನ ಇರಲ್ಲ, ಕಮ್ಯುನಿಕೇಶನ್ ಸ್ಕಿಲ್ ಇರಲ್ಲ ಅನ್ನುವಂಥ ಭ್ರಮೆಯಲ್ಲಿ ಇರ್ತಾರೆ. ದೇ ಆರ್ ಫಾರ್ ಬೆಟರ್ ಕಮ್ಯುನಿಕೇಟರ್ಸ್. ಸಿಟಿ ಅವ್ರಿಗೆ ಹೋಲಿಸಿದ್ರೆ ಅವ್ರ ಜೊತೆ ನಂಗೆ ಕೇಸ್ಗಳನ್ನು ಕೇಳಿದಾಗ ಇನ್ನೂ ಹೆಚ್ಚು ಖುಷಿ ಆಗ್ತದೆ. ನೇರವಾಗಿ ಪಾಯಿಂಟಿಗೆ ಬಂದ್ಬಿಡ್ತಾರೆ. ದೇ ವಿಲ್ ನಾಟ್ ಹ್ಯಾವ್ ಮಚ್ ಫ್ರಿಲ್, ಬಟ್ ದೇ ವಿಲ್ ಹ್ಯಾವ್ ದ ಫ್ರಾಕ್. ಸೊ ವೆನೆವರ್ ಯು ಕಮ್, ಜಸ್ಟ್ ಅಡ್ರೆಸ್ ಅವರ್ ಯಂಗ್ಸ್ಟರ್ಸ್. That helps.
I must not indicate some of my best moments at the bar here was opposing your lordship on the constitutional matters, particularly those local governments. They are still melons lingering in the Supreme Court.
But I was very badly beaten in that matter by you. Thank you. Yes.
The copy of the writ has to be served on the caveator. We'll serve the copy.
Copy ಕೊಟ್ಟಿದ್ದೀರಾ? ಕೊಡಿ.
We'll serve. We have to serve the copy.
ನೀವು ಕೊಡ್ಬೇಕು.
ನಾವು ಕೊಡಿ ಕೊಡ್ತೀವಿ.
Call this matter after occasion.
Please.
Okay. After occasion. In the meanwhile, copy of the petition shall be served on the caveator respondent. Yes. Yes, Pavana. Completed. Translation dispensed with. ಅದಕ್ಕೆ ಕರೆಕ್ಷನ್ ಏನ್ ಮಾಡ್ಬೇಕು? The mistake in the, ನೀವು ಮಾಡಕ್ ಬರಲ್ಲ ಅದು affidavit. The mistake in the verifying affidavit is liable to be ignored. Okay. ಸ್ಟಿಚ್ ಮಾಡಿ ಕೊಡ್ಬೇಕಾ? ಇದು ಸ್ಟಿಚ್ ಮಾಡಲ್ಲ ಪವನ ನೀನು. ಸ್ಟಿಚ್ ಆದ್ರೂ ಸರಿ ನೋಡ್ಕೊಳ್ಳಿ ಹೆಂಗೆ ಎಷ್ಟು ಆ ರೀತಿ ಯಾಕೆ ಹೆಂಗೆ? Are you angry with the judges or what? ಆಮೇಲೆ ಸ್ಟಿಚ್ ಮಾಡಿ ಕೊಡಿ. Yes. ಏನಿದೆ? ಆಲ್ ಅಷ್ಟೊಂದು ವರ್ಕ್ ತಗೋಬಾರ್ದು, ಬೇರೆಯವ್ರಿಗೂ ಬಿಡ್ಬೇಕು ವರ್ಕ್ ಮಾಡ್ಲಿಕ್ಕೆ. ಬೇರೆಯವ್ರಿಗೆ ಬಿಡು ಪೀಯರ ಬೇರೆಯವ್ರಿಗೆ ಕೊಡು. ಆಲ್ ರೈಟ್. Yes. What is this matter? ಎಷ್ಟು ದಿವಸ ಅಬ್ಸೆನ್ಸ್? ಬರೀ 159 days. ಅಂದ್ರೆ ಇಲ್ಲಿ ರೈಟ್ಸ್ ಗೀಟ್ಸ್ ಎಲ್ಲ ಆಗಲಿ, ನಾನು 159 days ಆರಾಮಿದ್ದೆ. Why he was away from service? ನೀವು ಬಿಕಾಸ್ ಆಫ್ ಮೈ ಲಾರ್ಡ್ ಅಂದಾಗೇನೆ ನಮ್ಗೆ ಭಯ ಆಯ್ತು. ನಾವೇ ಯಾವಾಗ ಅವನನ್ನು ಪ್ರಿವೆಂಟ್ ಮಾಡೇವಪ್ಪ.
Suddenly it is blocked. He is in the Melod continue escort service.
ಯಾರಿಗಾರ ಅಲ್ಲೇ ಹೊಡೆದಿದ್ನ ಏನು?
ಇಲ್ಲ, escort service, armed force. It's to the prisons only. Throughout the Melod day, he is serving. He is not able to go to the restroom. Then automatically Melod, when your abuse has been affected to his body, and informed when he admitted to the Mandya.
ಎಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್?
That has I produced there, Melod.
ನೋಟಿಸ್ ತೊಳಿ ನೋಡೋಣ.
But the contents, I just want to point out, Malak, there is nothing in the pleadings that at any point of time, until he returned back and reported to duty, there was a deserter notice also issued, and he did not report back to duty. There's nothing in the pleadings before the tribunal that he was suffering from illness. Until he came back, absolutely nothing. Nothing in the pleadings also. Nearly 5.5 months of absence, Malak.
Medical fitness certificate.
ಅಲ್ಲ, ಪ್ಲೀಡಿಂಗ್ಸ್ ಎಲ್ಲಿದೆ? ಮೆಡಿಕಲ್ ಆಯ್ತು. ವೇರ್ ಹ್ಯಾವ್ ಯು ಪ್ಲೀಡೆಡ್?
Pleading side, Melod, I have said.
earliest point of time.
The Lord may kindly peruse. With respect to the pleading is concerned, my Lord.
Ah.
That is, my Lord, started from. Running page number, my Lord, 7. Paragraph number 3. my Lord.
ಅದು ಪಿಟಿಷನ್ ಆಯ್ತು, ಅಪ್ಲಿಕೇಶನ್ ಬೆಲೆ.
Application. That is running page number 49.
49.
There is, my Lord, paragraph number 2. That is, it starts from running page number 52.
52.
Top, my Lord. 52. Running page number 52. It is submitted that on 29/1/2017, applicant was in accused escort duty, and after completion of the duty, applicant went to home, and on the same day, the night, applicant suffered by heavy stomach attack. And due to that impact, my Lord, he has suffered from heavy pain, and my Lord immediately informed to the competent authority saying that I am suffering. Even though that, my Lord, police has told no mens. Then I immediately rushed back to the, my Lord, office. Then again I suffered. Then, my Lord, all police, my brother police has, my Lord, has admitted to the hospital.
Yes, it's there.
But during the 159 days of absence,
Not.
never he
Anyway, this
brought
time,
to the
see,
attention of the
sometimes
authorities, my lord.
the stomach upset has saved this country. Do you know that? Have you read the Palkiwala story? Palkiwala and two others were briefed to argue on tax matter in Supreme Court. And all the three went to Bombay airport. In Bombay airport, Palkiwala suffered a tremendous stomach ache and he returned. Other two went in flight. Within 10 minutes, the flight crashed and two were dead. This is how Palkiwala survived and basic structure doctrine came in. Do you know that? We the people that see that. Anyway, it requires consideration, but emergent notice. All right, not a simple, we have seen that. Not an issue.
All the respondents, my lord.
Respond.
This much of harsh punishment not required. I will not, my Lord,
That's what.
claim, my Lord, any packages, any, my Lord, service with respect to the, my Lord, from last 5 years.
No.
My Lord, reappointment, my Lord, that's all.
No.
The Lordship has made a specific findings during the first time of proceedings. my Lord. That is, my Lord, it is annexed before this honorable court, when it becomes of 86.
Correct.
Wherein your Lordship has observed.
Myself and Joshi Sabu have written that. We know, we have read the papers.
Lordship has observed that it is a matter for consideration of 159.
Correct.
It's not intentional. I was not away from the department. I have informed.
It was intestinal, not intentional. That's what. Therefore, we are issuing notice, issue emergent notice. We call in the second week of June, we call this matter in the second week of June, since the matter lies in a very narrow compass. Okay.
Yes, your lordship, AG, your lordship, say Amar appearing this matter, short date.
You want time?
It should be that your lordship are filing objection, lordship. Filing objections also, lordship.
You are filing objections?
Today.
Good.
They have filed objections, my Lord. I filed my rejoinder also.
ಅವ್ರು ಮತ್ತೊಂದು ಏನೋ ಕೊಡ್ತಾ ಇದಾರೆ ನೋಡಿ. ಅಬ್ಜೆಕ್ಷನ್ ಕೊಡ್ಬೇಕಾರೆ ಬೇಡ ಅಂತ ಹೇಳ್ಬಾರ್ದು, ಕೊಡಿ ಅನ್ಬೇಕು. AG wants to appear in the first week of June. Call this matter in the first week of June. Finally, at the request of State Council. Yes. ನಿಮ್ರ ಮಾಡಿಲ್ವಾ? ಬಿಡಿ, make use of that. Yes. Next. Yes, brother. Anything.
There was a disciplinary inquiry, my lords, and some findings were given. The government did not agree with it, ordered for re-inquiry, my lords. And the re-inquiry was going on. I myself challenged re-inquiries 2023. It had progressed to some extent. I said the re-inquiry is bad, entire proceeding should be quashed. The learned tribunal accepted this, my lords, my plea that re-inquiry is bad in law.
Yes.
and remitted back the matter to the government. That is in 23 September. Inquiry was in
Remand was made.
remand, my lords. Nothing happened. Now, what I humbly pray is, my lords, the re-inquiry actually had proceeded further to some extent. Now, my lords, my humble submission is, if my lords, the government is matter was remitted back to the government, nothing has happened in 2 years, it will again take some years, my lords. My humble prayer is, though I myself went re-inquiry is bad in law, my lords, since it has progressed, my lords, I humbly pray that the re-inquiry which is ordered and it's at page 156, my lords,
Accomplished in a time bound way.
in a time bound way. That's all my humble prayer.
Is it right, no?
It's a reasonable.
Petitioner is knocking at the doors of writ court for assailing the state administrative tribunal's order dated 25/9/2023, whereby his application number 2219 of 2023 having been partly favored, re-inquiry whereby the order dated 12/4/2023 having been set aside, matter is remitted to the portals of the government for consideration afresh. First, learned senior advocate appearing for the petitioner in his usual fairness submits that though the order is now put in challenge, shorn of pleadings, if the court directs accomplishment of the remanded matter in a reasonable time, his client would be satisfied. Correct?
That's the order dated 12/4/2023 may be sustained, my lord. That re-inquiry
Satisfied, provided that the order dated
12/4/2023
is revived and sustained. Is revived and sustained. Occurred.
Direction we issued to partner.
First, learned AGA on request appearing for the official respondents, although initially opposed the petition, now he agrees with our view that the subject inquiry on remand has to be accomplished within a period of
Another 6 months.
6 months. Maximum ಇರೋದೇ 6 months.
ಅಲ್ಲಿ ಅವರೇ 3 months ಅಂತ ಹಾಕಿದ್ರು ಮೊದಲು ಮಾಡಲೇ ಇಲ್ಲ ಅವ್ರು ಅಂತ.
ಕೀಪಿಂಗ್ ಡೆಮೋಕ್ರಲ್ಸ್ ವರ್ಡ್ ಅದು ಒಂದ್ ರೀತಿ ಚರ್ಮ ರೋಗ ಇದ್ದಂಗೆ. ಯಾವಾಗ ಹೋಗುತ್ತೆ ಯಾವಾಗ ಬರುತ್ತೆ ಗೊತ್ತಾಗೋದಿಲ್ಲ. ಮುಗಿಸಿ ಒಂದು 3-4 months ಮುಗಿಸಿ. ಏನ್ ಬರ್ದಮ್ಮ? within a read fully. Within a reasonable period and in accordance with law. First up, in view of this fair stand, much discussion is unwarranted. First up, next up, in the above circumstances, this petition is allowed in part. 7. A writ of mandamus issues to the respondent again. To the respondent to accomplish or cause to be accomplished the hearing and disposal of the remand in terms of impugned order of the KAT.
My lord.
Within,
impugned order may kindly be set aside, my lord. Impugned order directs the government to again do it, my lords. Instead of that, my lords, now.
Remand within a period, in terms of Tagadu.
In terms of order dated.
In terms of order dated 12/4/2023, correct?
Please, my lords.
23. Within a period of 4 months. 4 months. First off, if delay is brooked, the inquiry shall be treated as having been abandoned.
Yes. And KCT order may be set aside and order of 12/4/23 we revived, my lords.
Admire helbittable.
In the operative portion.
The impugned order is to that extent modified.
Please, my lord.
No cost.
I'm greatly obliged.
ನಾಯ್ಕ್ರೆ ಏನಿದೆ? ಇದೆಯಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ
ಇದೆ ಸರ್, ಕಂಟಿನ್ಯೂ.
ಎಂಟ್ರಿ ಮಾಡಿ ಟು ಕಂಟಿನ್ಯೂ. ನೆಕ್ಸ್ಟ್.
Lord, appear for the caveat.
Six pass over.
Pass over.
Pass over. Is held up
Case
in
of
court.
premature transfer.
Is held up
I
in
was
court number 3.
prematurely transferred and no posting was given to me, my lord. Therefore, I was before the honorable tribunal. Tribunal has allowed my application, my lord. My learned friend is before this honorable court.
ನಿಮ್ಗೆ ಪೋಸ್ಟಿಂಗ್ ಕೊಟ್ಟರೆ ಹೋಗ್ತೀರಾ?
ಇಲ್ಲ, ನನಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ posting.
ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದಾರೆ?
Pursuant to the order passed, I was retained there, my lord. And
ನೀವು
my
ರಿಟೆಂಡ್ ನಿಮ್ದು ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ ಅಲ್ಲಿ?
ನಂದು 3 ವರ್ಷ ಆಗಿತ್ತು.
ಮತ್ತೆ ಹೆಂಗೆ
Minimum
retain?
period is 3 years, 4 years, as per the guideline. Group C post, my lord.
4 years.
ಹೌದು.
ಅವ್ರದ್ದು ಎಷ್ಟಾಗಿದೆ?
ಅವ್ರು 12 years in the ಹಾಸನಲ್ಲೇ ಇದ್ದಾರೆ. That is the case.
ಬೇರೆ ಬೇರೆ ಆಫೀಸ್ನಲ್ಲಿ.
Within the district. Therefore, the honorable tribunal, my lord, considering these facts, my lord, had allowed my writ petition, my lord, application, my lord.
Pass.
Pass. Please.
My lord, for respond number 4 to 5, my lord, 6 pass over, my lord, senior is
Pass over.
pass over. my lord.
This is a matter of lots.
ಏನೋ ಪಾಸ್ ಓವರ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ತೊಗೊಳ್ಳಿ.
On the last vacation, my lords, were virtually decided on merits in the sense, my lords. What had happened was this, my lords.
ಕರೆಕ್ಟ್. ನಾವು ಈಗ ನಾನು you know the latest developments. Therefore, we are requesting you. Are you aware of latest developments? You are.
I heard, my lords, and it is a sad
That's
thing.
what. Otherwise, we would have taken.
I don't want to say anything more. In fact,
Call after vacation, please. Call after vacation.
Petitioner, my lord,
Ah.
seeking component pension under rule 313 of the cases was rejected, my lord, by the first respondent. Thereafter, I filed the application without consideration, my lord, grounds the recommended by the SP and also DIG, my lord. The government has not considered, my lord.
Sorry.
Notice just.
Notice. Learned AG is requested to accept notice. ಎಲ್ಲ ರೆಸ್ಪಾನ್ಸ್ ಈಗ?
ಎಲ್ಲ response.
Yes.
For the petitioner rules.
Ah.
The petitioner is before this honorable court challenging the order passed by the Karnataka Administrative Tribunal, where a fresh inquiry has been ordered against the petitioner. My lords, the petitioner was working as a teacher, my lords, in Bellary, in a government school. She had sought for approval for pursuing B.Ed course. However, in the initial stages, the approval was rejected because there was lack of staff. Subsequently, she raised another request for pursuing B.Ed course, and that request was kept pending. And in view of the fact that the approval would be given, she pursued the course, my lord. And what has happened during the said period, she has taken leave. And the allegations are that she has withdrawn salary. It is true that the money has been deposited in her account, my lords. However, subsequently, she has even refunded the said amount. This is.
Remitted the money back?
Please, my lords, she has
Where is
remitted.
that? Show me.
My lords,
Show us.
your lordships may kindly see Annexure A17, my lords, in the operative portion of the
Page number ಹೇಳ್ಬೇಕು.
page number 166, my lords.
Remit ಮಾಡಿದಾರಾ?
Lord, first time ಬಂದಿದೆ instructions notice ಆಗಿಲ್ಲ.
ಅಲ್ಲ, if money is remitted, ಏನೋ ಒಂದು ವ್ಯಾಲ್ಯೂ ಅಡಿಷನ್ ಮಾಡಿಕೊಂಡಾರೆ, ಹೊರಗಡೆ ಹೋಗ್ಕೊಂಡು.
Lord, I'll find out,
ಮಾಡ್ಕೊಳ್ಳಿ.
first time ಬಂದಿದೆ madam.
Alright. Issue emergent notice. Learned AG is requested to accept notice for respondents. Entry ಮಾಡ್ರಿ ಏನ್ ಬೇಕಿಲ್ಲ.
My lords, fresh trial is ordered by the appellate tribunal, my lords. Fresh inquiry on the basis of the fact that rule 13 of the Karnataka civil service rules has not been complied with.
ನಿಮ್ ಜೊತೆ ಬೇರೆಯವರು ಇದ್ರನು?
Yes, my lords, there were others, and according to the
ಜಾಯಿಂಟ್ ಎನ್ಕ್ವೈರಿ ಆಗಬೇಕು.
joint inquiry.
Interim order as prayed for till next date of hearing. ನೋಡಿ.
Much obliged.
May I suggest, my lord, the inquiry may go on, but the report may be withheld.
What is that inquiry? ಎಲ್ಲ ಸ್ಟಡಿ ಮಾಡಿಕೊಂಡು ಕೋರ್ಸ್ ಜಾಸ್ತಿ ಮಾಡಿಕೊಂಡು ಮಾತ್ರ ಮಕ್ಕಳಿಗೆ ಮತ್ತೆ ನಾಳೆ ಮಕ್ಕಳಿಗೆಲ್ಲ ಎಜುಕೇಶನ್ ಕೊಡ್ತಾರೆ. ಇಫ್ ಮೋರ್ ಎಜುಕೇಟೆಡ್ ಮ್ಯಾನ್ ಕಮ್ಸ್, ಇಟ್ ವಿಲ್ ಬಿ ಎನ್ಯೂರ್ ಟು ದ ಬೆನಿಫಿಟ್ ಆಫ್ ದಿ ಚಿಲ್ಡ್ರನ್ ಅಲ್ವಾ? ಏನು ಫ್ರಾಡ್ ಇಲ್ಲ, ಅಮೌಂಟು ವಾಪಸ್ ಕೊಟ್ಟಾಗಿದೆ. ಎಸ್ ಬಾಬುರಾವ್.
A fixation based on the last pay drawn, my lord.
Last pay drawn.
And in objection also they have admitted.
ಲಾಸ್ಟ್ ಪೇ ಡ್ರಾನ್ ಅನ್ನು ಬೇಸ್ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ.
ಯಾವ್ದನ್ನ ಮಾಡ್ಕೊಂಡಾರೆ? ಎಷ್ಟು ವೇರಿಯೇಷನ್ ಎಷ್ಟಾಗ್ತದೆ?
350 ಇರಬೇಕು.
Emergent notice. The DG is request to accept notice for all response. Yes.
Obliged.
Like notice may be added in this minute.
There
Withholding of 10% pension.
214.
Yes, my lord. 214 1E.
All right. ಏನ್ ಮಿಸ್ಟೇಕ್ ಏನಿಲ್ಲ.
ಇಲ್ಲ
10% ಇದನ್ನ ವಿಥೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಬೈ ಆಫ್ ಪೆನಲ್ಟಿ.
Yes, my lord.
214 ಏನು ಮಿಸ್ಟೇಕ್? ವಾಟ್ ಇಸ್ ದ ಮಿಸ್ಟೇಕ್? Anyway, issue notice.
Yes, my lord.
214 2A ಅನ್ನೋದು.
Yes, my lord. 214 2A.
Yes.
Appearing for the petitioner.
Yes, Sarathi.
Withholding of 10% of pension. The allegation is that the petitioner reported as an assistant engineer on 19/1/2015. Date.
19/1/2015.
In the BBMP. 27/1/2015, an anonymous complaint has been given to Lokayukta. Anonymous complaint, holding that in a CA property, construction is taking place. In pursuance to that complaint forwarded to me, I conducted spot inspection. The property in which they quoted in the complaint, there was no such property found under site number 1B. So I submitted report holding that there is no such property under site 1B. However, after examination for another property there was a violation. So I have issued a notice calling upon to produce the sanction plan.
When did you, that was, by that time it was whole structure was complete.
No, that I reported only on 19/1. That construction has taken place 5 years back. That is
You reported on 19/1/2015.
Yes, sure, 15.
Then the construction happened when?
When the original sanction plan is 2005 and subsequent for the first floor they have issued in 2014 prior to me.
2014.
14 for the second floor.
ಎಷ್ಟು dimension?
Dimension 40/60.
ಮತ್ತೆ one floor ಅನ್ನ ನಿಮ್ ಟೈಮ್ ನಲ್ಲಿ at least one floor ಪೂರ ಇನ್ನು next floor ಮುಗಿಯಕ್ಕೆ ಸಾಧ್ಯ.
ನಾನು and my own motion I have conducted inspection. It is another property, not the complaint which they have given.
That's all right. It is another property is true.
I have conducted, I issued a notice and provisional order is also passed, final order is also passed. For that he obtained a stay before the civil court.
Why tribunal said it's a gross misconduct anta?
Gross misconduct, though I was there for 1.5 month. ನಾನು 19/1/2015
But you say, brother,
that is the
My lord, in this
1.5 month delay.
19/1/2015 ಗೆ ಬಂದ ನಾವು.
Yes, my lord. Construction was taken place in that
That
period
was
only,
long
my lord.
ago.
In that period only construction was
Second
taking
floor,
place.
first floor ಏನಿದೆ ಅದ್ರದ್ದು ಮಾತ್ರ he is speaking now. But ground floor ಏನಿದೆ that happened pursuant to 2006 sanction plan, 5 sanction plan ಅಂತ. Where is the gross misconduct? ಬಂದೆ 1.5 ತಿಂಗಳೊಳಗೆ ಬಂದ್ಕೊಂಡು one time ನೇ ಮುಗಿದದ. And he has taken action also. Issue emergent notice. Interim order as prayed for. Learned DG accepts notice for the response.
Obliged. Venkatesh Arbatti may be promoted.
Venkatesh Arbatti, panel counsel is requested to accept notice for
R4.
model R4 Lokayukta.
Obliged.
Yes, Satish.
Lord, matter pertaining to, my lord, the seniority list in the cadre of, my lord, the deputy superintendent of police. My lord, the petitioners are promotees, my lord, having been promoted from the feeder cadre of, my lord, inspector of police. Lord, the private respondent number 3 to 28 are, my lord, direct recruitees of the year 2017. Lord, right from their appointment.
Many vacancies have been, many persons' names are shown. The duplication also has happened. How many duplications?
473 minutes.
473.
Lord, in the after their appointment, provisional list was published, my lord, on 30/11/2017. All the petitioners are shown above the private respondents. None of them, my lord, the private respondents number 3 to 28 have filed objection to that list. Lord, that was not finalized. Then, my lord, on 3/7/2019, another provisional list was published. We are shown above. Then, my lord, another list was published on 28/7/2020. Even in that list, we have been shown above.
No, but whole problem is, the substratum is inherently defective.
Lord, even then,
How many duplications?
Volume 4.
the final list is
Volume 4, Court Officer,
Volume
4, page 924.
Lord, the final seniority list is dated 5/8/2021. Lord, in the final list, my lord, we have been shown above. They did not file objection. Right from, my lord, 2017.
Volume 1. Volume 1.
First volume.
First volume is part of the judgment in page 112, internal page 36, what your lordships are asking. Page 112, internal page 36.
112.
Can you turn to page 111, my lords? I'm sorry, 111.
One. Yes.
Para 18, the learned additional advocate general appearing for the respondents, tabulation statement containing the remarks of discrepancy pointed out in R15. Vacancy which have never arisen due to the following: number of vacancies wrongly, remarks, reply and discrepancies. Next page, my lords. The names found in the vacancy register but not reflected the impugn seniority list of DYSP and ASP 134. Serial number 1 to 69, these vacancy pertains to seniority published in 2013 in connection with Joshi's case. Serial number 16 to 134 have to be examined, then can be ascertained from the office records the necessary action to take action on merit. Repeated number and serial numbers is 99, my lords. This is what your lordships asked, my lords.
99.
99 repeated, my lords. Retirement of persons of 3 who 3 were placed under, that is 53 people, my lord, retired officers whose name are reflected
In the seniority list.
Please, my lord. Serial number 4, IPS officers posted
How they were under rule 32?
Total 346 members.
Totally 346. ಏನಿಲ್ಲ.
Lord, the
Notice don't ಹಾಕೊಳ್ಳಿ, it's not a case for interim order at all.
Lord,
Not a case for admission at all. But anyway, you both will argue. They are not a case for me.
only Lord, Lord, I'll make an attempt right from.
How are you going to overcome this
Lord,
table?
Lord, those lists have become final.
Correct. But with this,
Those lists have become final.
the structure is put with too many holes within, and nobody knows what all has happened.
Lord,
They were not aware of all these things. How they will know?
GT Ramaswamy says, my lord, unless, my lord, the lists are the previous lists have become final. Ranking assigned in the previous lists have become final.
Correct.
It cannot be tinkered with, my lord, in the.
In the sense, not one peripheral mistakes.
Final andre
That way, not having cancer inside.
Not only that, my lord, in GT Ramaswamy, 1976 seniority list had been upheld by this court in a challenge raised to it. Thereafter, on the basis of judgment in MG Kadali, they wanted to tinker with that seniority list. There this court, there this court said, Kadali has no application to this cadre at all. And it is a seniority list upheld by us. And you are revising it after 10 years.
With your lordships kindly, my lord.
Here, my lord, within.
My lord, in order to be fair to both the sides, my lord, what we propose to do, my lord, is just,
How are you on copy?
I'll just give it after reading. I'll just read it out and I'll give a copy to both the sides.
Tentative time schedule for implementation of case.
So the reason is, my lord, the factual situation will come out, my lord. Let us send serial government ordered to serial number 2 for constitution to be received within next week. After receipt of the government order, committee shall be constituted. After receipt of the government order with regard to the constitutional committee, time required for collection of records, verification, 3 months, my lord. Then publication of draft gradation list along with blockwise. 1 month, my lord. Then time given to file objection. We'll hear, my lord, objection to the draft gradation list. That is 15 days. For finalizing the objections raised by the concerned officer within 1 month, we'll do the final another 1 month from there on.
That's
So therefore, my lord, whatever my learned friend either parties has to say, my lord, we'll
can say all that.
So that and they can sit across, show it to them. That can be done so that it will be in a transparent manner. My lord.
This proposal appears to be excellent, subject to what Mr. Rajgopal will say. Rajgopal may object to this one, but I do not know how you can object, Mr. Satish. It is so fair. They say we will do everything according to this.
Within a time
Arda
schedule,
page-
within a time schedule also, my
ಆ
lord.
ಟೈಮ್
ಅರ್ಧ
ಶೆಡ್ಯೂಲ್
page-
ಅವರು ಆ ಕಮಿಟಿಗೆ 3 months 4 months ಏನೋ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹಾ.
ಆಲ್ರೆಡಿ ಹೆಡ್ ಆಫ್ ದಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅವರಿಗೆ ರೆಕಮೆಂಡ್ ಮಾಡಿ ಕಮಿಟಿ ಫಾರ್ಮೇಷನ್ ಗೆ 1.5 ತಿಂಗಳು
ಆಮೇಲೆ ಅವರೇ ಕಂಟೆಂಟ್ ಹಾಕ್ಬಿಡ್ತಾರೆ my lord.
ಅಲ್ಲ ಈ ಪ್ರಪೋಸಲ್ ಸತೀಶ್, ಈ ಪ್ರಪೋಸಲ್ ಬಗ್ಗೆ ಏನು ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿದೆ? ಲಾಯರಿಂಗ್ ಬಿಡಿ, ಲೀವ್ ಯು ಅಸೈಡ್ ಯುವರ್ ಲಾಯರಿಂಗ್ ಸ್ಕಿಲ್.
I given it to my learned friend, my lord. I've given it. Sorry.
ಕೇಳ್ಕೊಂಡು ಹೇಳ್ತೀರಾ?
Yes, my lord.
ಕ್ಲೈಂಟ್ ಕನ್ಸಲ್ಟ್ ಮಾಡಿ ಹೇಳ್ತೀರಾ?
Yes, my lord.
So let them come up with.
ಅಷ್ಟೇ.
Your lordship may.
ಮೇ ಮುಂದಿಂದೇನು? ಮೇ ಇಸ್ ಕಮಿಂಗ್ ಆಫ್ಟರ್ ಏಪ್ರಿಲ್. ಕಂಪ್ಲೀಟ್ ದ ಸೆಂಟೆನ್ಸ್.
Next week, my lord.
ಏನು ಅಷ್ಟು ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿವೇ ಯು ಮೇ ಹ್ಯಾವ್ ಎ ಗುಡ್ ಬೆಂಚ್ ಆಲ್ಸೋ. ಯು ಆರ್ weeding away all bad people now.
Sorry, my lords, don't, my lords may not use, you are weeding it. Sorry.
No, I'll take.
Some bar people say, some bar people.
Sorry, my lords, never carry that impression, please.
Absolutely, my lord. I second my learned friends.
In fact,
Court may not.
in fact, I was telling somebody outside that unless we learn to protest, we will perish. Not that our protests will always be successful.
No,
but
no,
then
we don't subscribe to
feelings,
that view.
my view, I am entitled to tell, Manoj.
We do not subscribe because
View will have to be expressed.
some all wisdom has entered policy decisions. The policy decisions they take.
That is the whole thing, my lord.
Well, suppose in every transfer matter, we quote Varadarao. Why should not you go? Then that applies to us also.
sir.
We should go with all.
Service
pleasure.
law does not
That
apply
is-
to constitution ಅಂತ 10 ದಿನದ ಕೆಳಗೆ ತಾವೇ ನಂಗೆ ಹೇಳಿದ್ರಿ.
ಇಲ್ಲ ಹಂಗಲ್ಲ.
Constitutional positions ಅಂತ.
Whenever a soldier is posted, it is his
Yes,
duty to
that-
go to the war
From
zone.
my lord's point of view,
That's what.
I accept. But from this side, something more is called for.
But
not in the
ಎಲ್ಲ
open.
think-
Not
ಎಲ್ಲ
in the, I am not be entitled to say it here, but my lords would excuse my frankness, which has always been like this.
ಎಲ್ಲ think ಮಾಡಿಕೊಂಡು ಹಿರಿಯರೆಲ್ಲ ಅದೆಲ್ಲ ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ. ನಮ್ಗೆಲ್ಲ ಕಳಿಸ್ತಾರೆ.
ಅಲ್ಲ, ಹಿರಿಯರು
ಕೆಲ್ಸ
ಅದೆಲ್ಲ-
ಖುಷಿಯಿಂದ
ಗುರಿ ಹಿರಿಯರು ನಿಶ್ಚರಿಸೋದು ಎಲ್ಲ ಕರೆಕ್ಟ್. ಏನು ಹೇಳಲಿಕ್ಕೆ
ಕೆಲಸ ಮಾಡ್ಬೇಕು. ಸಿಂಪಲ್. ಏನೋ ಎಲ್ಲಿನ ಫೆಸಿಲಿಟಿ ಇದೆ ನಮ್ಗೇನು ಹಿಮಾಲಯ ಕಳಿಸಿದ.
Himalaya is also part of India.
That's what. If High Court is established there and if I
ಒಂದು ಬೆಂಚ್ ಮಾಡಿದ್ರೆ
I will go there. No issue. Application ಹಾಕೊಂಡು ನಾನು
In meanwhile, let the government proceed with its program.
ಗವರ್ಮೆಂಟ್ ಪ್ರೊಸೆಸ್ ಮಾಡ್ಲಿ ಇದನ್ನ.
Please.
ಬರ್ಕೊಳ್ಳಿ. ನೋಟಿಸ್, ಇಶ್ಯೂ ನೋಟಿಸ್.
Lord,
They have filed 4 volumes, man. It's a good ground to issue notice.
ಹೇಳಿ.
I am filing a memo for deletion of my lord respond number 29 and 30. They are the
29, 30.
original
ನೋಡಮ್ಮ.
sailing with the petitioners.
Petitioners have filed a memo.
Delete ಬೇಡ. Notice may be dispensed.
Yeah, notice may be dispensed. I am filing a memo for dispensation of notice.
Seeking dispensation of notice to
Lord, respondent number 29 and 30.
29 and 30. 29 and 30. First memo accepted.
My learned friend appears for, Lord, my learned friend may be directed to take notice for
notice.
respondent number 3 to 28.
Shri, yeah, the briefing council, Shri, so and so. Appears for the contesting respondent numbers 3 to
28.
28.
R1 and R2, my lord,
And,
government advocate.
They are represented by learned senior advocate, Mr. Rajgopal. Yes. Next paragraph. Learned AGA appears for
Respondent number.
official respondent.
R1 and R2.
R1 and R2. First. Learned Advocate General appears for the implementation of tribunals that is put in challenge in these applications. First up. They having heard that counsel for the parties and Yes, in the first week of August 2025.
Please.
ಎಷ್ಟಿದೆ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ತುಂಬ ಇದೆ ಬೇಡ ಏನು just in cup of sec. Yes, Mr.
No, no,
Raju.
nothing.
Sir, 2 minutes, 2 minutes. Come back.
Combinations of different things.
It actually comes out well because I use the best butter. They get cows, so it's a rare open pasture. Ingredients.
Yes. Also the texture. You're like, I think, seriously.
I enjoy cooking. I do it for relaxation.
Madam, kita
ರೇಂಜ್ ಅಂತ
ಒಂದು ರೇಂಜ್ ಅಂದ್ರೆ how many acres of forest, area of forest, ಹೆಂಗ?
No, it is excise inspector.
ಇದು ಎಕ್ಸೈಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್.
ಆ ರೇಂಜಿಗೆ.
ಎಕ್ಸೈಸ್
Range includes how many taluks?
It is within the district.
How many
Is that seven?
district ಗೆ ಒಂದ ರೇಂಜ್?
ಇಲ್ಲ ಬೇರೆ ಬೇರೆ ಇದೆ.
ಬೇರೆ ಬೇರೆ range.
in 30 ಅಲ್ಲ ಮಂಗಳೂರಲ್ಲಿ ಇದು ಹಾಸನಲ್ಲೇ ಎರಡಿದೆ 1 and 2 ಅಂತಿದೆ. ಈಗ 1 ಇಂದ 2
ಅಲ್ಲಿ ಹೆಚ್ಚು ಜಾಸ್ತಿ ಕುಡಿಯುವಂತ ಊರು ಯಾವುದು?
ಈಗ ಎಲ್ಲ
ಅದು ತಿಳ್ಕೊ.
ಈಗ ಅರ್ನಿಂಗ್ ಇಸ್ ದೇರ್ ಓನ್ಲಿ.
You are also right in saying that. ಭಾಳ ಡಿಫರೆನ್ಸ್ ಇಲ್ಲ ಆ ವಿಷಯದಲ್ಲಿ. Equality.
ಲಾರ್ಡ್ಶಿಪ್
21 ಇಂದ
21 ಇಂದ ನಾನು ಹಾಸನ್ ರೇಂಜ್ 1 ಅಲ್ಲಿ ಇದ್ದೆ ಸ್ವಾಮಿ.
ಹಾಸನ್ ರೇಂಜ್ ಅಂದ್ರೆ ನಾವು ಎಲ್ಲ ಒಂದೇ.
ಈಗ ಹಾಸನ್ ರೇಂಜ್ 1 ಇಂದ ಹಾಸನ್ ರೇಂಜ್ 2 ಗೆ ಇದು ಮ್ಯೂಚುವಲ್ ಐ ಟುಕ್ ಇಟ್.
Earlier you were in ಹಾಸನ್ ರೇಂಜ್ 2
my lord.
ಅಲ್ಲಿ you want
third respondent was working my lord.
ಏನಿಲ್ಲ ಎಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆ. ಅಷ್ಟು ವರ್ಷ ಒಂದೇ ಕಡೆ ನಿಂತ್ಕೋಬಾರ್ದು.
ಅಲ್ಲ ಬಿಕಾಸ್ ಆಫ್ ಈಸ್ my lord the
ಅವ್ರು ಎಷ್ಟು ವರ್ಷ ಇದ್ದಾರೆ?
I'll first time.
ಅವರು 4 years because of mutual transfer my lord he was disturbed. Otherwise my lord he would be entitled my lord.
Heard dismissed. Next.
The wife also my lord working my lord. He cancer patient my lord.
ಯಾರು?
Applicant is a cancer patient. Therefore my lord the accommodated my lord in the near places only my lord.
ಏನ್ ಕ್ಯಾನ್ಸರ್ ಅದು?
My lord
ಯಾವ ಕ್ಯಾನ್ಸರ್? What is the stage?
Stage is my lord. Treatment is taking my lord in
what is that cancer? Cancer 180 types cancers ಇದೆ. ಅದರ ಕೆಲವೊಂದು ಕ್ಯಾನ್ಸರ್ ನಿಂದ ಆರಾಮ್ ಎಂಜಾಯ್ ಅಲ್ಮುನಿಗೂ ಹೋಗಕ್ಕೆ ಬರ್ತದೆ. We are asking what is that cancer your client is having? Just show that if it is there we'll do something.
ಅಲ್ಲ readings ಅಲ್ಲಿ ಹೇಳಿದೀನಿ.
Our ಕಬ್ಬಿನ್ ಸಾಹೇಬರಿಗೆ ಎಷ್ಟು ವರ್ಷ?
also my lord the
Kabin Sahib was such a good judge in KAT for how many years after having contracted cancer? That's not the answer. Cancer 1930 ಒಳಗೆ ಕ್ಯಾನ್ಸರ್ ಅಂದಾಗನೇ ನಾವು ಹೆಂಗ್ ಮಾಡ್ತಿದ್ದೆ ಹಂಗಿಲ್ಲ ಈಗ.
ಅಲ್ಲ ಕಪಲ್ ಕೇಸ್ ಇದೆ ಆಫ್ಟರ್ ಕಂಪ್ಲೀಷನ್ my lord maybe.
Couple is not a cancer.
ಅಲ್ಲ ಕ್ಯಾನ್ಸರ್ my lord ground my lord. One is a ground my lord urgent my lord.
For few it may be.
After completion of 4 years my lord he may be permitted.
What is your cancer? You are not answering the court's question. Why are you avoiding? What is the kind of type of cancer? What is the stage of cancer? Show that.
Stage is not in the first stage my lord, in the preliminary stage my lord.
ಎಲ್ಲಿದೆ ನಿಮ್ಗೆ ಏನು ಮೆಟೀರಿಯಲ್ ಹೇಳಿ?
ನಾನು ಅದರಲ್ಲಿ ಯಾವುದೋ ಒಂದು ಕೇಳಿಲ್ಲ ಅದು ಹೇಳಿದ್ದಾರೆ. ಬಟ್ ಇದು ರಿಪ್ಲೈ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ನಾಟ್
ಹಂಗೆ ಅಷ್ಟೇ ಹೇಳಿದ್ರು.
ಅಲ್ಲ ಆಫ್ಟರ್ 4 years my lord is right to submit the word of postman 4 years my lord. After completion of 4 years my lord
ಅಲ್ಲೇ ಇರಬೇಕು ಅಂತೀರಾ? ಅವಾಗ ಗವರ್ಮೆಂಟ್ ವಿಲ್ ಕನ್ಸಿಡರ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಟ್ರೈಬ್ಯುನಲ್ನವರು. ಏನ್ ತಪ್ಪಿದೆ ಅದರಲ್ಲಿ? It is for the government to decide where you should be posted, where you should not be posted. ನಾವೆಲ್ಲ ಕೋರ್ಟ್ನವರು ಇವ್ರನ್ನ ಇಲ್ಲಿ ಪೋಸ್ಟ್ ಮಾಡ್ರಿ, ಅವ್ರನ್ನ ಅಲ್ಲಿ ಪೋಸ್ಟ್ ಮಾಡ್ರಿ, ಇಲ್ಲಿಗೆ ಆರ್ಮಿ ವೈರಿ ಹಂಗೆ ಹೇಳಿಕ್ ಬರ್ತದ ನಾವು? Government of the day, in its experience, wisdom, it decides those things.
Once he is given a consent my lord.
Consent ಕೊಟ್ಬಿಟ್ರೆ you do not go outside the public law, the transfer policy. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಎಲ್ಲರೂ ಹಂಗ ಮಾಡ್ಕೊಂಡ್ಬಿಡ್ತಿದ್ರು. ನಾವು ಒಂದು 10 ವರ್ಷ ಇಲ್ಲಿರ್ತೇನೆ ದೋಸ್ತ, ನೀ ಅಲ್ಲಿರು ನಾ ಇಲ್ಲಿರ್ತೇನೆ, ಮ್ಯೂಚುವಲ್ ಮಾಡ್ಕೊಂಡು ನಾವು ಇಲ್ಲಿಂದ ಬಿಟ್ಟು ಎಲ್ಲಿ ಹೋಗೋದೇ ಬೇಡ ಅಂತ. ಹಂಗ್ ಬರಲ್ಲ. ಟ್ರಾನ್ಸ್ಫರ್ ಪಾಲಿಸಿ ಗೈಡ್ಲೈನ್ಸ್ ಎಲ್ಲ ನೋಡಿ, ಅವನ್ನೆಲ್ಲ ನೋಡಿದ್ರೆ some experience, some wisdom emanates from the experience. ಹಂಗಿದಾವ. ಅವ್ನು ಬೇರೆ ಅದ ಪೀಸ್ ಆಫ್ ಲಿಟ್ರೇಚರ್ ಓದ್ದಂಗೆ ಓದ್ಬಾರ್ದು ಟ್ರಾನ್ಸ್ಫರ್ ಗೈಡ್ಲೈನ್ಸ್ ಅಂತ. You should read them and you should accept the wisdom of the transfer guidelines. Lot of wisdom ನಿಂದ ಅದಕ್ಕೆ ಹಂಗಾಗಿ ಬೆಂತ ಇವನು ಆಲಿವರ್ ವೆಂಡಲ್ ಹೋಮ್ಸ್ ಬರೆದಿದ್ದು ಕಾಮನ್ ಲಾದಲ್ಲಿ, the life of law is not logic, it is experience. ಆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ನಲ್ಲಿ ಎದ್ದು ಹುಟ್ಟಿದೆ ಅದು ಟ್ರಾನ್ಸ್ಫರ್ ಗೈಡ್ಲೈನ್ಸ್. ಏನಿದೆ ಬಿ ಗ್ರೂಪ್ ಓದಿ ಹೇಳಿ ಡೇಟ್ ಕೊಟ್ಟು ಕತ್ಕೊಂಡು.
Lords, on the last occasion, the Lordship had directed to submit a book, my Lords, to the advocate.
ಯಾವ book?
Anomalies in law, my Lords.
ರವೀಂದ್ರನ್ ಸಾಹೇಬ್ರು.
Yes, my Lords.
ನೀ ನೋಡಿದೆ? ಓದಿದೆ?
I read that. I read a few pages.
Complete all pages. It's a good book.
Certainly.
Call it after vacation.
My Lords.
Vacation ಆದ್ಮೇಲೆ ಮಾಡೋಣ.
Lords. Okay.
ಪ್ರಕಾಶ್.
Next week could be much better.
Next week will be better to you, but to us,
grateful.
Let's see.
Sorry about that. Serial number 25, there was a problem in the VC. Lord, it has been, whether it is called or not.
ನೀವು ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ನಾವು ಕಾಲ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂದಿವಿ ಅಷ್ಟೇ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲ ಆಗ್ಬಿಟ್ಟದೆ, ಇಲ್ಲಿ ಡಿಸ್ಕನೆಕ್ಟ್
Sign
ಆಗಿಬಿಟ್ಟಿದೆ ಸ್ವಲ್ಪ ಪ್ರಾಬ್ಲಮ್.
ಸೈನ್
ಐ ಆಮ್ ಸಾರಿ ಮೇಡಮ್, ಐ ಆಮ್ ಸಾರಿ ಮೇಡಮ್.
ಸೈನ್ ಆಗಿದೆ ಅದಕ್ಕೆ.
ಐ ಆಮ್ ಸಾರಿ ಮೇಡಮ್, ಐ ಆಮ್ ಸಾರಿ.
ನೋಡ್ರಿ ಸೈನ್ ಆಗಿದೆ ಇಲ್ಲ? ಇಟ್ ಈಸ್ ರಿಟರ್ನ್ ಆಲ್ರೆಡಿ. ಅದರ್ವೈಸ್ ವುಡ್ ಹ್ಯಾವ್ ಚೇಂಜ್.
Please madam, I am sorry madam.
Yes.
Grateful.
Application ಮಾಡೋಣ please.
In this case, your lordship, Ashwini Haladi, your lordship, he is a
ಇವ್ರು ಬರ್ತಾರನಲ್ಲ, Ashwin Haladi is permitted to retire and in his stead Mr. Anthony Joseph appears. ಏನು ಶಾಸ್ತ್ರಿಗಳು ಏನಿದು?
The petitioners are working on daily wages as my lord, hostel wardens for the last 31 years.
31 years.
ಟ್ರೈಬ್ಯುನಲ್ ಹೋದ್ರೆ ಅಲ್ಲಿ ವಜಾ ಮಾಡಿದ್ರು.
ಮೇಲೆ
ಒಂದು my lord ಡಿಲೇ ಅಥವಾ ಅಂದ್ರೆ ಸ್ಟೇ ಆರ್ಡರ್ ವಾಸ್ ದೇರ್ ಇನ್ WP 8192 of 1993 ದಲ್ಲಿ. ಆ ಸ್ಟೇ ಮೇಲೆ ನಾವು ಮುಂದುವರೆದಂತೆ. ದಟ್ ವಾಸ್ ಎ ಜನರಲ್ ಸ್ಟೇ obtained by ಫೆಡರೇಷನ್.
6890 ಆರ್ಡರ್ ನಲ್ಲಿ ಸ್ಟೇ ಆರ್ಡರ್ ನಿಂದ ಕಂಟಿನ್ಯೂ ಆಗಿರಬಾರದು
ಅದು ಅದನ್ನ ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಕ್ಲಾರಿಫೈಡ್ ಬೈ
another order,
this honorable court in division bench. ಅದು ಒಂದು. And my lord, we have not
daily wages Brahma.
They have been brought under the
daily wages in the
Daily Wage Welfare Act ಕೆಳಗೆ ತಂದಿದೀವಿ ಇವ್ರಿಗೆ.
ಇಲ್ಲ, ಅದನ್ನ ತಗೊಂಡಿಲ್ಲ. That benefit we have given letter stating that we will not accept, since we have approached this honorable court. My lord, we are not accepting. My lord, the persons, similarly situated person
covered ಆಗತ್ತನ?
ಹೌದು
ನೋಡಿ,
ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿ
before the tribunal they have not, there is a finding that they have not produced any document to show that when they were appointed and to whether they were appointed against sanction posts. There is a clear finding that the appointment is illegal and not irregular.
My lord,
the tribunal has given a finding.
Apart from that, how it is illegal? In that case also illegal ಅಂತ ಹೇಳಿದ್ರು, and you argued so vociferously, but we did not agree with that. In that case also, which my brother wrote,
ಇಲ್ಲಿ document to produce ಮಾಡಿಲ್ಲ. Several opportunities, the finding of the
recommended
tribunal
ಮಾಡಿದ್ದಾರೆ.
is several opportunities were given.
A6 and A7. Not
A6 A7 na?
A6 and A7.
Yes.
Page 69.
69.
Please. My lord, there was a direction issued by this honorable court, my lord, for consideration of regularization as per annexure A3, page 45.
69 ಹೇಳಿದ್ರಿ ಮತ್ತು
ಸಾರಿ 45 ದಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರು.
69 ದಲ್ಲಿ ಏನಿದೆ?
69 ದಲ್ಲಿ my lord, district social welfare officer recommends.
ಹೆಸರೇನು?
Serial number 3 and serial number 10.
ಜಗದೀಶ
and
ಶ್ರೀಕಂಠಯ್ಯ. A6 ಬನ್ನಿ ಬ್ರದರ್.
My lord, the recommendation has been considered and rejected, my lord. That is the endorsement at page, my lord, page 148, my lord. Annexure A17 and A18 also, because there are two petitioners in this matter, my lord. On two grounds, the claim for regularization is rejected. Because in Umadevi's 4 conditions were specified, my lord.
It has been considered,
One is
my lord, in
that
Venkatapati
they should have been appointed against sanction posts. They should have the qualification for the post. 10 years without the intervention of the courts, my lord. The second condition that they should have the qualification, because this is a warden's post, my lord. Degree is required. That they did not possess.
As on which date?
My lord, they don't have a degree, my lord.
What was the qualification according to you?
Degree, my lord. My lord, it is mentioned at page 150, my lord.
150.
150.
Which is the rule?
Adhisoochane sankhye so and so, my lord, your lordships may see the last para at the bottom of the page at page 149, my lord.
No, that one only I saw that. Please. But which is that rule anta? ವೃಂದ ಮತ್ತು ನೇಮಕಾತಿ ನಿಯಮಗಳ ಕುರಿತು ಸರ್ಕಾರದಿಂದ ಈ ಹಿಂದೆ ಹೊರಡಿಸಲ, which is that? ಅದು ತೋರಿಸ್ಬೇಕಲ್ಲ. 85 ದಲ್ಲಿ ಏನ್ ರಿಕ್ವೈರ್ಮೆಂಟ್ ಇತ್ತು ಅಂತ.
These petitioners were also
ತೋರಿಸ್ಲಿ. 85 ದಲ್ಲಿ the requirement to become warden is a degree ಅಂತಿತ್ತು ಅಂದ್ರೆ, then as you rightly said, we cannot bring them there at all. ಅವಾಗ ಇಲ್ಲಿಗಲ್ ಆಗತ್ತೆ.
Indeed.
ಅದನ್ನ ಬಿಟ್ಕೊಂಡ್ ಮಾಡೋದು ಇಲ್ಲಿಗಲ್ ಆಗತ್ತೆ. ಬಟ್ ಈ ರೂಲ್ಸ್ ಅನ್ನು ತೋರಿಸ್ಬೇಕು ನೀವು.
ಆಗ್ಲಿ.
ಅವ್ರ ರೇವಣ್ಣ ಅಂತ ಒಬ್ಬನು ಸೀರಿಯಲ್ ನಂಬರ್ 24 in the earlier writ petition ಅವರನ್ನು ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಿದ್ರು.
ಅವರು ವಾರ್ಡನ್
ವಾರ್ಡನ್.
What was he? It went Revanna's
Our
case went to
warden.
Supreme Court. Revanna's case, we remember,
Supreme
it
Court.
went to Supreme Court.
ಹೌದು.
Then
ಇವರು ಅದೇ
we gave
petition
to that other lady. In that,
ಅದೇ ಪಿಟಿಷನ್ ಅಂದ್ರೆ ಇವರು ಇದ್ದಾರೆ.
ಅಲ್ಲ ಯಾವ ಪೋಸ್ಟ್ ಬೇರೆ ಬೇರೆ ಪೋಸ್ಟ್ ಇದಾವ ಅದಕ್ಕೆ.
ರೇವಣ್ಣಂದು ವಾರ್ಡನ್ ಪೋಸ್ಟ್
ಎಲ್ಲಿದೆ ಅದು?
ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 40.
ರೇವಣ್ಣಗೆ ಡಿಗ್ರಿ ಇರ್ಲಿಲ್ಲ ಅಂತ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಒಟ್ಟು
what he says is, Revanna's case after division bench, state went to the Supreme Court. Supreme Court dismissed the SLP. Based upon Revanna, my brother wrote that judgment.
Yes, yeah, this person was also my lord in the very same writ petition.
Question is, does he have that required qualification? That's one point. That torsi ಮಾಡಿ ಹಾಕ್ಬಿಡೋಣ.
That may be recorded in the order, my lord. I'll specifically verify on that point.
Learned DGA drawing attention of the court to page 149 and 150 of the petition papers tells that the petitioners lacked the prescribed qualification of a degree, bachelor's degree, to become the wardens, First off, he is instructed to produce a copy of the extant rules published by notification dated 5/8/1985. Torsi note. First off, he also should tell as to whether Mr. Revanna had that said qualification and therefore his services have been regularized pursuant to judgments of this court, which ultimately came to be affirmed in SLP. ಇಷ್ಟು ತೋರಿಸ್ಬಿಟ್ರೆ ಮುಗಿದ. ರೇವಣ್ಣಿಂದ ಡಿಫರೆಂಟ್ ಇದ್ದಾರೆ ಅಂದ್ರೆ ಅವಾಗ ಮೈ ಬ್ರದರ್ಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ವಿಲ್ ನಾಟ್ ಬಿ ಅಪ್ಲಿಕೇಬಲ್. ಇಫ್ he is with ರೇವಣ್ಣ, then same thing. ಅದು ನೀವೇ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು.
ಇದರಲ್ಲೂ he was also a petitioner ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ.
ಅಲ್ಲ ನೋಡೋಣ, ಅಟ್ ಲೀಸ್ಟ್ ನಮಗೆ ಶೋ ದಟ್ he is having ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇಲ್ದಂಗೆ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿಗಲ್. ವಾಟ್ he says is right because of that ಯಾವುದು ನಂದಲಾಲ್ ಕೇಸ.
Umadevi itself says.
Umadevi itself says, yes. Yes.
And the latest case also, Jaggo's case also. In Jaggo's case also,
Kesari does not
they have
dilute that.
admonished the government for rejecting regularization even in case of irregular appointees, where it's not illegal.
Alla, ML Kesari does not dilute that view.
Certainly.
But any post equivalent to their qualification, my lord.
ಅದು ನೋಡೋಣ, at least ಆಲ್ಟರ್ನೇಟಿವ್ ಆಗಿ ಗೊತ್ತಾಯ್ತಾ ಅವ್ರು ಹೇಳೋದು.
May I get a
ಆ
copy of
ಪೋಸ್ಟ್
that
ಇರ್ಲಿಕ್ಕೆ whichever post
judgment of
he is entitled to. Where
No, this is Venkatraju.
Revanna has been produced.
ಕಾಪಿ ಕೊಟ್ಟಿರಿ, ಒಂದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
Revanna ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೇನೆ. It is at my lord Supreme Court judgment we have produced.
ಹೇಳಿ. Okay, please. Immediately after vacation.
Please. Next week.
Next week ಆಗಲ್ಲ. Yes. Yes, Professor Nagarajan.
My lord, in writ petition number 11292, I'm the first petition in this case, my lord. 11292.
31.1.
Yes, my lord. So senior is held up in health checkup, my lord. He couldn't able to come today. Kindly.
We want date.
Kindly pose the matter tomorrow, my lord.
Tomorrow. Tomorrow is holiday. You are not celebrating that Friday? Yes. Call after vacation to enable counsel for the petitioner to come and argue. Yes.
My lord.
ಏನಮ್ಮ?
It's an urgency, my lord. Kindly.
ಅದಕ್ಕೆ ನಮಗೂ ಅರ್ಜೆಂಟ್ ಇರೋದಕ್ಕೆ ಬೇಗ ಹಾಕಿದ್ವಿ. Immediately after vacation. ಅದೇ ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದು ಎಲ್ಲ ಹೆಂಗ್ ತೊಗೊಳ್ಳಿ ಎಲ್ಲ ನೀವೆಲ್ಲ ಅರೆಮನಸ್ಸಿನಿಂದ ಡಿಸೈಡ್ ಮಾಡಂಗಿರಲ್ಲ. ಸ್ವಲ್ಪ ಮೈಂಡ್ ಅಪ್ಲೈ ಮಾಡಿ ಮಾಡ್ಬೇಕಾಗ್ತದೆ. ನೋಡೋಣ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ಏನಾರ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದ ಇವ್ರ ಕೇಸ್ನಲ್ಲಿ? Ordinarily, government is as a litigant is entitled, it is a prerogative to choose the lawyers. But ಅಷ್ಟು free ಇರಲ್ಲ APP ವಿಷಯದಲ್ಲಿ. They enjoy statutory status. ಯಾವುದು famous judgment UP judgment ಇದೆಯಲ್ಲ.
ಇದೆಲ್ಲ ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ ಇದೆ. ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಎನ್ಕ್ವೈರಿಯಲ್ಲಿ ಇದೆ, ಇನ್ನೂ ಬ್ಯಾಚ್ ಒಂದಿದೆ, ಬ್ಯಾಚ್ ಆಫ್ ಪಿಟಿಷನ್ಸ್ ಆರ್ ದೇರ್.
ಅವೆಲ್ಲ ಕೊಟ್ರೆ ಎಲ್ಲವನ್ನು ಮುಗಿಸ್ಬಿಡ್ಬೋದು. ನಂಬರ್ ಕೊಡ್ತೀನಿ. All these matters after occasion, immediately after occasion, along with the other connected matters, list of which should be furnished by the learned AGA.
My lord, I am requesting kindly post the matter on Tuesday, my lord. Senior will hear the matter.
Kindly have it in, we are also requesting you, have it after immediate occasion. Yes, very difficult ಅದು APP ಏನಾಗಿದೆ ನಮ್ಗೆ because of latest development. Otherwise we wanted to take this. My brother wanted to settle the law on this point. In fact, we wanted to do that, but now because of latest development. Otherwise, we had discussed, we have seen this last time
last time bandit.
Yes, my brother wanted, law should be settled in this regard. Either ಯಾವುದೋ ಒಂದ್ ಕಡೆ government complete, they can take anybody, they can remove anybody, hang ಮಾಡಕ್ ಬರಲ್ಲ ಅನ್ನೋದು my brother's view. Even I am of that view only, because it is not some private engagement. Government is a constitutional body. It cannot just whenever they want they can engage, whenever they do not want they can remove. ಆ ರೀತಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡ್ತೀರಾ?
ಆಗ್ಬೋದು
ನೋಡಮ್ಮ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಡಿ. We want to settle this way or that way.
Yes, ma'am.
Because otherwise ಇದೇ ರೀತಿ ಬರ್ತಾ ಹೋಗ್ತದೆ ಅನ್ನೋದು.
ಹೌದು.
But so far as I am concerned, my lords, I was only the delegate who prepared the question paper. That was my limited role. I put in a counter on those aspects of the matter before the KAT.
Aditya, in matters like this, how they should be decided according to you? Forget that you are an advocate appearing for anybody.
Please. Lords, I bow down that government has to act in a fair way, my lords, and consistent way. But here an exam was conducted, there were specific grievances about, so far as my role is concerned, the manner in which.
Nim role bidi.
That's all.
We are
But
not on
so
your
far as state
your
is
client is
concerned,
only a
my lords,
delegate of this.
Please, I'm only a delegate. But I bow down, my lord. So far as state is concerned, it has to.
ಏನೋ ಲಾ ಸೆಕ್ರೆಟರಿ ಜೊತೆ ಏನಾದ್ರು ಮಾತಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲನು?
ವಿಚಾರಿಸಿ ಮಾತಾಡ್ತಾರೆ.
ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಕೇಸ್ನಲ್ಲಿ ಮಾಡಿದ್ವಲ್ಲ ನಾವು.
ಹೌದು.
ಆ ರೀತಿ ಅವ್ರ ಜೊತೆ ಕೂತ್ಕೊಂಡು ಮಾತಾಡಿ, ಅದು ಕ್ವಶನ್ ಈಸ್ ನಾಟ್ ಓನ್ಲಿ ಜಸ್ಟ್ ಜಾಬ್, ಇಟ್ಸ್ ಕ್ವಶನ್ ಆಫ್ ದಿ ಸ್ಟೇಟಸ್. ಅವರು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದು ಹೆಂಗೆ ಅಲ್ಲಿ ಹೊರಗಡೆ ಹೋಗಿ ಆ ನಮ್ನಿ ಸ್ವಲ್ಪ ಸ್ಟಿಗ್ಮ್ಯಾಟಿಕ್ ಅಂತ ಪರ್ಸೀವ್ ಮಾಡ್ತಾರೆ ಜನ.
ಹೌದು.
ದೆನ್ ನಾಳೆ ಕ್ಲೈಂಟ್ಸ್ ಅವ್ರನ್ನ ನಂಬೋದು ಹೆಂಗೆ, ಮಾಡೋದು ಹೆಂಗೆ? ಸೊ ದೇ ವಿಲ್ ಬಿ ಪುಟ್ ಟು ಪ್ರಾಬ್ಲಮ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗ್ಬೋದು.
ನೋಡ್ಕೊಂಡು ನೀವು ಹೇಳ್ಬೇಕು.
ಆಗ್ಬೋದು.
26 ಇದೆಯಾ? ಅದಾದ್ಮೇಲೆ ಯಾವ್ದಿದೆ? 24th ಹಾಕೋಣ.
24th ಬಹಳ ಮ್ಯಾಟರ್ಸ್ ಇದಾವೆ.
ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಇದೆ.
KPSC ಇದೆ.
28th ಹಾಕೋಣ.
ಆಗ್ಬೋದು.
ಓಕೆ.
ಗ್ರೇಟ್ಫುಲ್.
ನೋಡಿ ಒಂದು ಸ್ವಲ್ಪ ಏನಾರ ಒಂದು ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
ಆಗ್ಬೋದು.
ಹೆಂಗೆ ಅಂತ
ಆಗ್ಬೋದು. ಏನಿದೆ?
The petition. The matter pertains to the regularization of daily wage services. The petitioners are completed more than 30 years. Lord, before the tribunal, my lord, have been.
No, after occasion.
It is my lord's covered by judgment. It was supplied the copies.
Covered by
I have to verify, my lord, next week.
28th ಹಾಕೊಳ್ಳಿ ನೋಡಿ.
26th
ಅದು ಒಂದಿದೆಯಲ್ಲ, ಅದು
28th.
Great.
Yes. Ramoli.
Your Lordship, yes, this is the case with regard to the.
ಏನು urgency ಇದೆಯಾ?
Urgency is that she is the only bread earner of the family, Your Lordship. There's nobody
Dismissed
else.
from service on the ground of producing false SSLC marks.
False marks card, which contained more marks. Did it contain? Because last time you saw that there was a false marks card, but it contained the same marks only.
Despite
806. 806.
In spite of taking the actual marks, he had the highest.
Tell me that. ಇದರಲ್ಲಿ ಏನಾಗುತ್ತೆ? Fake mark card
Get
produce
well as
ಮಾಡಿದ್ದು
the-
ನಿಜನಾ? Is it true? Do you understand Kannada?
Yes, yes, of course, Your Lordship.
False mark card ಯಾವ್ದು ಕೇಸು? ಮೊದಲನೇ ಕ್ವಶನ್ ಈಗ ಎರಡನೇ ಕ್ವಶನ್.
Yes, sir. The cases with regard to allegedly producing the false marks card.
Marks card
And-
produce ಮಾಡಿದ್ದು ನಿಜನಾ?
She had produced the marks card, but they have said that it is false marks card, Your Lordship.
Oh,
They have
according to-
compared it with a
Original.
original, no, they had gotten a mark sheet from the board itself.
It's very
It
evident,
said-
my lord. R1 and R2 are what have been produced. I think those documents have not been produced along with the
Your
petition.
Lordship, they have not compared it with the
As soon
original
as we
marks
look at
card.
those documents, it becomes.
Original marks card ನಲ್ಲಿ ಎಷ್ಟು ಮಾರ್ಕ್ಸ್ ಬಂದಿದೆ ಅವರಿಗೆ?
So they have not produced the original marks
You
card.
produce that original marks.
Your
You are
Lordship, the original marks card is lost by the petitioner.
It
That
will be
is-
available with the authorities, na? You might have lost, but these are all maintained as public records. Private records maintained in the public office. You produce that.
I agree, Your Lordship. Since the government had already taken, had asked for the,
Prima facie to show us, sir, ನಮ್ಮ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್ ನೋಡಿ, ಇದು ಸರಿ ಇದೆ.
I understand.
ಇಷ್ಟೇ ಕೇಸ್, ಇದಕ್ಕೆ 5 ವರ್ಷ ಬೇಕಾ? ಆರ್ಗ್ಯುಮೆಂಟ್ ಅವನಿಗೆ ಹೋಗಿದ್ದೆ, ಅದು ಯಾವುದೋ ಒಂದು ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಅವನು 3 ಆಡುಗಳು ಕಳೆದು ಹೋಗಿದ್ವು ಅಂತ, ಕುರಿಗಳು. ಅವ ನಮ್ಮ ಕುರಿ ಕೊಡಿಸಿ ಅನ್ಕೊಂಡು ಕೇಸ್ ಹಾಕಿದ. ಇದು ಕುರಿಗಳ ಉಗಮ ಸ್ಥಾನ ಯಾವುದು, ಎವಲ್ಯೂಷನರಿ ಹಿಸ್ಟ್ರಿಯಲ್ಲಿ ಕುರಿಗಳು ಎಲ್ಲಿ ನಿಲ್ತಾವೆ, ಯಾವ್ಯಾವ ಇಪೋಕ್ ನಲ್ಲಿ ಏನೇನ್ ಆಗ್ತಿತ್ತು, ಕುರಿಗಳ ಡೀಲಿಂಗ್ ಹೆಂಗಾಗ್ತದೆ, ಆ ರೀತಿ ಮಾಡ್ಕೋತ ಕೊಡಕ್ ಬರ್ತದೆ. ಶೋ ಯುವರ್ ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್, ವಿಲ್ ಗ್ರಾಂಟ್ ಯು ರಿಲೀಫ್.
much obliged, Your Lordship. And
1,000 rupees, you'll get duplicate.
ಡೂಪ್ಲಿಕೇಟ್ ಸಿಗತ್ತಲ್ಲ.
ಅಲ್ಲ R1 R2 ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಸಾಕು ಅವರು. ನಾವು ಟ್ರೈಬ್ಯುನಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು.
Don't
I
worry,
requested
R1
the government officer my lord on the last
So
occasion.
much time is
ಅವರು
spent.
ನಮಗೆ ಕೊಡ್ಲಿಲ್ಲ, ಇವರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ.
ಇವರೇ ಮಾಡ್ಬೇಕು. ಸೆಕ್ಷನ್ 107 ಯಾವ್ದು ಇದೆಯಲ್ಲ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ನಲ್ಲಿ.
They have not produced the annexures which we had
Especially
submitted.
within whose knowledge he should produce. You produce much.
much obliged.
Petitioner,
Yes.
counsel
R1
for
and
the petitioner, petitioner is directed to produce the duplicate mark cards that would match with the document numbers at annexure A1, R1 and R2.
Produced along with the reply statement.
R1 and R2, which we find in the reply statement filed by the official respondents before the tribunal.
Before the tribunal, yes.
Okay. Failing which, an adverse inference may be drawn to sustain the order of the tribunal. Okay.
Your Lordship, just one humble submission. We will produce the documents for sure, but if I could just press on the second prayer of our petition.
What
It
is that
says
second?
That she had worked from 18 March 2020 to 17th of May 2022. She had worked without any pay, Your Lordship. No salary was disbursed.
ಅವಾಗ ವರ್ಕ್ ಮಾಡಿಸಿರ ಅವ್ರ ಕೈಯಿಂದ ವರ್ಕ್ ಮಾಡಿದ್ರೆ ದುಡ್ಡು ಕೊಡಬೇಕಾಗತ್ತೆ. ಬಿಕಾಸ್ ಆರ್ಟಿಕಲ್ 23 enacts doctrine against beggar.
Sorry, but the appointment has been,
No,
if it has been appointed,
no, that's all right.
secured
When you-
appointment by fraud.
No, we will tell you. In that high court
Could
registrar.
not have been in that place at all if she had not produced the.
That's all right. If Adam and Eve had not eaten the apple, nobody would have born at all. But that's not the case. They ate apple and were born. Question is, if you have extracted work, then 96 Supreme Court, ಯಾವ್ದು registrar, Shardama, registrar High Court of Gujarat versus Government of Gujarat, where Supreme Court said, even a criminal undergoing the punishment, if you extract work from him, you have to make the payment. ಅದು 2 ವರ್ಷ ಕೊಡಬೇಕಲ್ಲ, ಅದು ಅಸರ್ಟನ್ ಮಾಡ್ಕೊಂಡು ನೆಕ್ಸ್ಟ್ ಡೇಟಿಗೆ ಹೇಳ್ಬೇಕು. Counsel for the petitioner.
Your Lordship,
No, no,
if I may just
May I
produce
just-
the judgment given by the Supreme Court, it's a division bench judgment, which says that for the period of time that the employee has
Worked.
discharged
Yeah,
work,
to-
they're entitled to be given the salary, Your Lordship.
But the question may arise whether he was a willing employee of the employer. Because the
Fraudulent
employment
ಅಲ್ಲ
has
ಅಂತ.
been secured by fraud.
ಅವಾಗ ಫ್ರಾಡ್ ವಿಷಯಟ್ಸ್ ಎವ್ರಿಥಿಂಗ್ ಆಗತ್ತೆ ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್. ಅದ್ ನೋಡ್ಕೊಂಡು ಹೇಳಿ, ಆ ಟೈಮ್ನ ಕೊಟ್ಟಾರ ಇಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಹೇಳಿ. ಲೆಟ್ ಅಸ್ ಸಿ, ಲೆಟ್ ಅಸ್ ಎಕ್ಸಾಮಿನ್. Counsel for the petitioner complains that even for the period between
Between 18th March 2020 to 17th,
and
17 May 2022, Your Lordship.
2022, comma, her client has actually put in service, and for that period, no wages have been paid. First of all, she also tells that in not making payment for the work extracted, comma, Article 23 of the Constitution is violated in the light of Apex Court decision in Registrar, High Court of Gujarat versus the government of Gujarat. They have the judgment 95, 96, which is that? Notಕೊಂಡು ಹಾಕಲ್ಲ. First, the government advocate has to come out with an answer to this on the next date of hearing, failing which a direction may be issued for making the payment. Yes, you have to tell them.
Can it be taken up next week, my lord? It can be concluded if this is the only issue.
Yes, very well.
They can produce R1 and 2 and I will
Yes, Your
Produce,
Lordship.
no, procure that, you require some time, no?
Yes, Your Lordship. If you could just give us at least a
28?
week's time.
28?
Sure, sure,
Call
Your
this
Lordship.
matter.
Much obliged.
Yeah. You have to bring that judgment also.
Yes, Your Lordship.
Which is
I
that
have it.
Gujarat
I
judgment.
have it. This is the, this is.
That is a different,
from-
that is not a case of fraud.
Sure,
You have seen that.
I'll
Masi,
submit
perhaps.
it.
ನಾನು ಕೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ, ನಾನು ಆಫೀಸರ್ ಅನ್ನು ಕೇಳಿದ್ದೀನಿ, ಅವ್ರು ತಂದ್ಕೊಟ್ಟಿಲ್ಲ.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ. 98, AR 98 Supreme Court, 3164. Just look into. Where criminals are made to, they were paid the salary, wages. You can't make them to work, saying that you are all condemned people, therefore you should work freely. The Apex Court did not agree. Yes. Vigar means, word vigar is found in the constitution itself. Vigar means working a man to work, making a man to work without salary or salary less than what he is entitled to.
Now, this is regarding deduction from the DCRG amount, my lord. Rafiq Mahishi case, my lord.
Rafiq Masi.
Please, my lord. My lord, from relied on the recent judgment, my lord. Even as per the recent judgment also, my lord.
Rafiq Masi is a cadre specific. Lower cadre, ನೀವು ಹೇಳೋದು KR Singh ಸಾಹೇಬ್ರದ್ದು.
Group C, my lord. Group C.
Group C. Group C is in. What do you say, brother?
Recent judgment.
They have also decided that matter, no, particular. If without their fraud, etc., if something more is paid to them, you cannot recover. Is the decision of Justice KR ಸಾಹೇಬ್ರ judgment ಅದು ಅಲ್ವಾ? ಅದನ್ನ ಫಾಲೋ ಮಾಡಿ ಇನ್ನೊಂದು ಬಂದಿತ್ತಲ್ಲ, ಇದೆಯಾ?
Recent judgment also my friend relied on. Para number 13, my.
What tribunal said?
Because since there is no hardship, my lord, in the representation, therefore we can't interfere.
Not like that. 2020.
Para number 13, my lord.
This Sahu matter.
Please, para number 30, my friends, because Rafiq Mahishi case is referred in the
1-3.
Please, my lord. 13, page number 30, para number 30.
Punjab versus Rafiq Masi, wherein this court examined the validity of an order passed by the state recovered monetary gains wrongfully extended to the benefit for interest without any fault or misrepresentation on their part. ಇದರಲ್ಲಿ fault or misrepresentation ಇದೆಯಾ?
No, ma'am.
ಇಲ್ಲ. ಫಾಲೋ ಮಾಡಬೇಕಾಗತ್ತೆ. ಬರ್ಕೊಳ್ಳಿ. Petitioners are grieving against the state administrative tribunal's order, whereby their application number so and so, calling in question the recovery order, has been negative.
24/7.
First, learned counsel for the petitioner
Acted on the ground of delay also, my lord. They, after retirement, they have approached.
where they should go. In case of retirement, you can't say that one.
The ground is.
Learned counsel for the petitioner vehemently argues that it has been the consistent view of the apex court of the country that where excess payment has been made for the entitlement of employees of lower segments, comma, that cannot be recovered unless there is some fraudulent involvement of the employee concerned. First, this aspect having been not properly appreciated by the tribunal, relief has been wrongly denied to his client. First, learned AGA appearing for the official respondents per contra make submission in justification of the impugned order of the tribunal, saying that the tribunal has specifically recorded a finding as to the absence of hardship which the petitioner has suffered, and therefore the ratio in Rafiq Masi nor in Jogeshwara Sahu comes to the aid of petitioners. First, so contending, he seeks dismissal of the writ petition. Next, having heard the learned counsel for the parties and having perused the petition papers, were inclined to grant indulgence in the matter, in as much as petitioner belongs to petitioner belongs to group C, and apparently he fits into the operative portion of the postulates of Rafiq Masi. First, it hardly needs to be said that the hardship need not be pleaded in in so many words. First, hardship can be assumed when the petitioner, having served service madiri
32 years
served for more than 3 decades, has been superannuated, and now he has been in the evening of his life. First, next paragraph. We have the coordinate bench of this judgment area. They should be treated with soft gloves. Another coordinate bench headed by KS Bracketnally, headed by KSDJ, has held that the pensioners who have put in public service have to be treated with compassion and soft gloves, since overseas a constitutionally ordained welfare state in the light of apex court decision in next paragraph. In recovery madara athwa payment madbeka
ಡಿಡಕ್ಟ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ DCRG
in the above circle ಅಲ್ಲಿ ಇನ್ನೊಂದು sentence ಬರ್ಕೋಬೇಕು. The state and its instrumentalities cannot defeat a worthy cause on an unsure ground of delay and laches, more particularly when the cause is brought forward by the pensioners. First, next paragraph. In the above circumstances, this petition succeeds, semicolon, a writ of certiorari issues quashing the impugned order of the tribunal, semicolon. Petitioner's application number
1421 minutes. 1421 of 2023.
1421 of 2023 having been favored, impugned order dated
24 July 2023
has been quashed. First off, a writ of mandamus issues to the respondents to pay back to the petitioner all that has been recovered.
Withheld amount. Withheld amount of
recovered
PCRG
or recovered from the DCRG. Within what period? Within 8 weeks. Semicolon. Delay, if brooked, will attract interest at the rate of 2% per mensum, which may be recovered from the erring officials after paying it to the petitioners.
39 years.
Right?
He worked more than 39 years.
39 years. Nearly 4 decades. Call. Rafiq Masi, ಮತ್ತೆ ಇದು ಸಾಹು ಇದನ್ನ ಎರಡನ್ನು ಸ್ಟ್ರಕ್ಚರ್ ಮಾಡಿ ಜಡ್ಜ್ಮೆಂಟ್ ಕರೀರಿ.
Serial number 39 में लो Sorry, my lord.
39,
Serial number
just
39. It's a matter relating to pension. The retired person is not having even payment for medical things. May not kindly have it at least Monday or Tuesday. May not. Because with great
28,
difficulty I got it posted. May not.
28 ಹಾಕೊಂಡಿರಿ 28 ಹಾಕಿ.
He is being paid a provisional pension, my lord.
Provisional pension payment ಇದೆ ಅಂತಲ್ರಿ.
Suppressed certain facts at the time of
39.
filing the application.
Provisional pension
38
ಕೊಡ್ತಾ ಇದ್ದಾರೆ
again.
ಅಂತಲ್ಲ 38 ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
39 ನಲ್ಲಿ ಸ್ವಾಮಿ.
39 ದಲ್ಲಿ provisional pension ಪೇ ಮಾಡ್ತಾ ಇದಾರಲ್ಲ. ಅದು ಬರಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರಲಿ.
Serial number 35, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ?
39.
Serial number 35, my lord.
1 second. That K.M. Prakash appears for
R2.
R2. Okay. ಯಾರು ಏನು ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಇನ್ನೊಬ್ರು.
Serial number 35, my lord. The regulation has been done, my lord, but we are only requesting for extension of the benefit only after completion of 10 years, my lord. I take the support of your lordship's decision, my lord, in the case of Venkatraju, my lord. That is decided on 10/3/2025, wherein, my lord, only regarding extension of the benefit after 10 years, my lord. Regulation has
ನೀವು
been...
ಕತ್ಲೆಯಲ್ಲಿ ಯಾಕೆ ಕೂತ್ಕೊಂಡ್ರಿ?
I am
ನಿಮ್ಮ
sorry, my
ಆಫೀಸ್
lord.
ನಲ್ಲಿ ಕತ್ಲೆಯಲ್ಲಿ ಯಾಕೆ ಕೂತ್ಕೊಂಡ್ರಿ?
ಇಲ್ಲ ಅದು ಸ್ವಲ್ಪ ವಿಡಿಯೋ ಡಿಫರೆನ್ಸ್ ಆಗ್ತದೆ.
ಡಾಕ್ಟರ್ 28 ಹಾಕಿ ನೋಡೋಣ.
ಮಚ್
13 ಇದು ಆನ್ ಮಾಡ್ಕೊಳಕ್ ಬರಲ್ವಾ?
Please. Serial number 37, my lord. Matter, my lord, very simple, my lord. Matter pertaining to selection of D group, my lord. The tribunal rejected the application at the time of admission itself, my lord. Because of, my lord, the petitioner had produced all the documents, my lord. At the time of verification, my lord, the original marks card of SSLC misplaced, my lord. Your lordship already directed the similar earlier date, my lord, whether the vacancy is available on that post or not. I have produced along with memo, my lord, vacancy is there, my lord.
Even now there is vacancy.
Please, my lord.
28 ಹಾಕಿ ನೋಡೋಣ.
Please, 28.
28. All right.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಗ್ಬೇಕು ಮೇಡಮ್.
ಸಿಂಗಲ್ ಅಲ್ಲಿ ಜನ ಮಾಡ್ತಾನೆ ನನಗೆ
Court of Court of What of the?
Lord Christmas, the petitioner father is successful in coming before this honorable court and getting ex parte stay orders and ensuring that the child is not given to the mother at all, please, my lords. And my lords, I can give you a few citations. Yes,
my lords. Absolutely false submission, my lords.
Child is with whom?
The child was transferred, the custody was transferred to the faster because of disobedience and violation of Order 39 injunction before the Honorable Trial Court.
What it said?
On 15/10/22.
What it said?
It said she cannot take the child outside the jurisdiction of Bangalore, which she violated 3 times. 3 times NBW, 2 times she was arrested, 5 lakh rupee bond. All of them had been violated. So custody was transferred and she was told, if you want to retain custody, come back to Bangalore and make the child admitted to a local school in Bangalore. She does not comply that also. That is why custody was transferred. And on 15.
Slowly, 1 second. There should be pause. There is no pause in your statement.
I'm sorry.
That is the problem with you people.
I'm sorry. On 15/10, after the completion of the interim custody for Dasera vacation, she herself files a memo saying, let the custody continue with the petitioner father. He is the petitioner in the court below, my lords. And after that, she does not attend the court hearings. That is how from the last 2.5 years, the child is with us. The father, she's admitted to a wonderful school. She's doing very well. And he has never blocked, unlike the mother, the access to the mother via video calls every day. Whenever she comes to Bangalore.
Which place mother is from?
Mother is at 3 locations in India, my lord. We don't know where she is.
False.
One is Malda.
1 second. Which place she is from?
Sorry, my lords. My lords. She's actually from Malda, West Bengal, my lords. She's working there. She's born there. She's been taking care of the child even there, my lords. If I may please interrupt. One minute, please, my lords. Daivitu, page number 18, please, my lords. In the document I've given, please, my lords.
1/8.
In this, yes, my lords, 1/8.
These are the documents I do not
Orders
have, my
on
lords.
IA2, please, my lords, wherein I've given the complete concise, my lords, not to confuse this court, please, my lords. Page number 18, please, my lords. Orders on IA2. The petitioner has filed IA2. Petitioner is the father in G&W. Family judge, please, my lords. The petitioner has filed IA2 under section 7 of the G&W Act to grant interim custody of the child, that's a girl, daughter Arshita, on all weekends in the interest of justice. Kindly see the order passed, please, my lords, which is in page number 20, please, my lords. Last para, please, my lords. The IA2 filed by the petitioner is rejected. However, the petitioner is permitted to have access with the child through phone and video conference. Further, if the petitioner wishes to meet the child at Malda, West Bengal, during the holidays of the child, he could visit the child with prior intimation to the respondent in her residence during the daytime. My lords, kindly note the date of order, please, my lords, 19/4/2018. Subsequent to this, my lords, the father comes before this honorable court, a coordinate of this honorable court. My lords will find this in page number 22, WP 18121 of 2018. In this order, please, my lords, in page number 25, the last 4 lines.
Yes.
Challenges IA2, my lords, in page number 25, please, my lords. Last 5 lines. The impugned order is accordingly quashed and the family court is directed to decide the application filed by the petitioner father afresh by speaking order within 6 weeks from the date of receipt of the certified order of the copy. Now, please, my lords, page number 26. The order again is passed by the family court dated 2/8/2019, please, my lords, wherein IA2 filed by the petitioner under section 7 is partly allowed, but there are no changes, my lords. The petitioner is permitted.
Sorry, what kind of argument, advocacy? Why can't you read some standard book on advocacy?
Sorry, my lords. IA2 is filed by the petitioner under section 7. It is partly allowed. The petitioner is permitted to have access with the minor child through phone or video conference at a convenient time without affecting the health and education of the minor child with prior information.
Now child is admitted to which school?
She's
My lords, till 7 years, she was in Orchid School, my lords.
In Banerghatta Road.
My lords, if I please, I may be allowed to just complete this one thing, please, my lords.
I've read, I don't take so much time to read.
My lords, IA8 ali, my lords. They fraudulently bring IA8, my lords. If my lords can just see that and get a contradictory order.
You bring that child to the court.
The child.
I want to interact with the child.
At the moment, the child is on vacation with the father for the first half of the vacation. Because
that's all right. The judge is entitled to talk to the child or not?
Of course, my lords. We can arrange video conferencing today only.
Where is the child?
They are in Andaman Nicobar, Port Blair. So it's
My
a
lords.
long vacation.
1 second.
It's a long vacation. After that, he's on a tour. Because second half, she will ask for interim custody. That's why first half he is exercising.
Second half, you will
Now
give
the-
the
my lord,
child
She
to,
has applied and that.
no, whether you tell me, your first half you have taken.
I'm coming to it, my lords.
Ah.
That order is coming on 19.
Don't worry, we will make order. Any order we can make.
Yes, yes, my lords, of course. I
Now
bow
she
down.
is mother.
I bow down on parents' patria. We are okay with daytime interim custody in Bangalore. Because if she has overnight access, she will again take away the child per contra to all the violations.
We can bring her back with police help.
That is what we have been doing from 3 years.
We
my
will do
lord.
that, don't
After getting
worry.
From
contradictory
3
orders.
years.
Please be seated.
From 3
Please
years.
be seated. Otherwise not before. Call this matter before some other judge since counsel
Sorry,
is
my lords.
interrupting.
My lord, sorry, my lords. Sorry, my lords.
Please be seated, means be seated. I will hear you. I will not pass any adverse order without hearing you, sister.
Sorry, my lords.
I will hear you also.
So as per the itinerary submitted before the honorable trial court,
All right. There is
Then-
nothing like trial court, final court in these custody matters.
yes, my lords.
Court is
Please.
the parent patria.
Please, parents' patria. I
Now,
bow down to that.
half of the vacation you have taken.
Yes, my lords.
You don't want her to take the child for half of the vacation.
Outside Bangalore, we don't want.
But you have taken to Andaman Nicobar.
From 22, the child is with us.
Ah.
As per the.
You
wish-
can take your child
No,
to
no.
Andaman Nicobar or to the moonland, but mother should
No,
not
my
take
lords.
it.
The child wanted to learn snorkeling.
Huh?
Every activity of the child is being taken care of.
Child should be with the mother. She is 9-year-old. If you agree that after child comes back, you will give that child to the mother, well and good.
Please.
Otherwise, we'll pass the order now.
That WPs are also pending before coordinate bench.
Very well, we'll pass an order now.
Please.
You let her produce that order before the coordinate
From
bench.
the father's side, he is absolutely agreeable to give custody to the mother, but in Bangalore.
In Bangalore, nowhere she should take the child.
There is scope for that also, my lords, provided this honorable court imposes conditions because.
We'll impose conditions. That
I
we will
leave
look
that-
into.
I leave
She
that
is
to your
mother.
lordship. I leave that to your lordships. Now, there is a buffet of 17 cases between the parties. Now, what has happened in one of the cases very important with the context, my lords. She has complained to the registrar vigilance against the honorable third additional family code. And please, because that is the next case at serial number 6. And she has directly threatened that once she gets custody of the child, she'll file a POCSO case against the father, which we brought to the notice of the honorable coordinate bench. He has protected us in 3 498 cases filed by her.
We'll continue that
Please.
protection also.
Please, please.
We'll continue that protection
Because
also.
the point being made is about puberty. The honorable Supreme Court has read that girly things should not come in the way of custody with respect to the father. And about parents' patriate,
No, anyway, you know the parent patria jurisdiction. It is enormous.
absolutely.
Its extent is it is coextensive with the requirement of doing justice.
Absolutely.
Therefore,
So if
its
the father
enormity,
is-
we need not argue at all.
If the
Now,
father is protected.
you have taken the child to Andaman and Nicobar. Is it?
Andaman Nicobar, Kodaikanal is. the
Kodaikanal and all beautiful places in the country, very well.
Please,
Now
please.
let the mother take the child wherever she wants, subject to the condition
Please, please.
that she shall not do anything and she will bring back the child on the next date of hearing.
Please.
With this, you are agreeable?
Please.
One second,
And
madam.
for point.
May I?
Yes, Deshpande ಅಲ್ಲ? ಹಾ,
Can I, my lords?
ಹಾ.
My lords,
ಈಗ ವೆಕೇಶನ್ ಯಾವಾಗಿದೆ?
my lords, simple.
ಒಂದೊಂದು ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಲ್ವಾ?
ಖಂಡಿತ my lords. 24/3 ಗೆ my lords,
Vacation
ತಾಯಿ application
ಯಾವಾಗಿದೆ?
ಹಾಕ್ತಾರೆ. 10th ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ my lords.
ಹಾ,
10/4 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗಿ.
10th of December.
No my lords,
ಮತ್ತೆ
ಈಗ
ಹೇಳ್ಬೇಕು.
ಏಪ್ರಿಲ್ 10/4 ಇಂದ
10
ಸ್ಟಾರ್ಟ್ ಆಗಿ
ಒಂದ್ ನಿಮಿಷ. 10/4/2025.
till
All right.
Till
When it comes to an end?
4th of June.
21st May.
Huh?
4th of June.
21st May.
4/6.
My lords,
I'm telling the official.
Officially you
It
are
is
saying.
4/6.
my lords, the mother is before.
We'll ask the, what mother will say, we'll ask the regulatory.
I know the.
ಸ್ಕೂಲಿಗೆ ಫೋನ್ ಮಾಡಿ ಯಾವಾಗಿಂದ ಇಲ್ಲಿಗೆ ಅಂತ ಕೇಳ್ಕೊಡ್ರಿ.
4/6 ನಾನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
4/6/2020.
ನಾವು ಅದು ಸಬ್ಮಿಟ್ ಮಾಡಿದೀವಿ. ಟೈಮ್ ಟೇಬಲ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
My lords, may I?
Yeah.
My lords, the mother had put an application seeking interim custody of the child for the summer vacation on the 24th of March, my lords. The father has even put the objections. In spite of requesting the child's interim custody for 10/4/2025, my lords, deliberately the father takes the child away from the jurisdiction of the family court, please, my lords.
ಆರ್ಡರ್ ಇದೆಯಾ ನಾಟ್ ಟು ಟೇಕ್ ಅಂತ?
ಇಲ್ಲ.
My lords,
ರೈಟ್ ಟು ಟ್ರಾವೆಲ್ ಇಸ್ ಎ ಫಂಡಮೆಂಟಲ್ ರೈಟ್.
illa, my lords, ika, my lords,
Is there restriction?
my lords, the basic contention here is,
Don't
my
want to
lords,
answer. What kind of advocacy is yours? You don't want to answer the court's question also?
please, my lords.
We are asking you. is there any restraint in the order? You say yes or no, then now you argue.
My lords, there is a restraint in IA 8, which by default is also for the petitioner father, my lords. When IA 8 has come in, it cannot be only for the mother, my lords. In
We
fact,
do not know what is the order.
please, my lords. My lords, IA 2, which was again affirmed in page number 33, even on 8/3/2022.
ಈಗ ಹೀಗ್ ಮಾಡೋಣ. ಈಗ ಅವ್ರೆಂಕು ಈಗ ಹಾಫ್ ವೆಕೇಶನ್ ತಗೊಂಡಾಗಿದೆಯಲ್ಲ. Let that half vacation child be with the mother. Child should spend time with the mother. That's very important.
Please, please,
ಹಾ.
please.
ಇರ್ಲಿ,
I
ಯಾವತ್ತು
am an
ಕರ್ಕೊಂಡ್ ಬರ್ತೀವಿ
advocate
child?
for shared parenting, my lords. I
Correct.
believe in shared parenting to the core. I would
So,
appreciate. But she
all
should.
right, you ಏನೋ ಕೆಲಸ ಮಾಡ್ತೀವಿ advocacy
Let's-
ನಿಮ್ಮವೆಲ್ಲ.
ಇನ್ನು
False
one-
advocacy. See, now when the child is coming.
The child will be back on 10th, which is the father's birthday. 10th of. 10th of.
Let him celebrate 10th also with the
Yes,
child
that is what he
only.
requested.
10th of
May.
May. ಎಷ್ಟು ದಿವಸ ಆಗ್ತದೆ ಅವಾಗ?
ಅವಾಗಿ ಸ್ವಾಮಿ, ನಮ್ ಪ್ರಕಾರ.
10th of May ಇಂದ 4/6/25 ವರೆಗೆ ಇದು ಇದೆ.
ಹೌದು ಸ್ವಾಮಿ, ಇನ್ನೂ ಇದೆ. Yes.
10th birthday, date of birth ಕೊಡಿ ಅವ್ರದ್ದು. Father's date of birth. Give that.
Date of birth application ನಾವು ಎಲ್ಲ ಇದೆ ಬಾಂಬೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ? ಇದನ್ನ ತರಿಸ್ರಿ, ಆಧಾರ್ ಕಾರ್ಡ್ ತರಿಸ್ರಿ ಇಮಿಡಿಯೇಟ್ಲಿ. ತರಿಸ್ರಿ ಇಮಿಡಿಯೇಟ್ಲಿ. ಅಂತ ತಗೊಂಡು ನಾವೇನ್ ಮಾಡೋಣ?
My lords, may I make one submission, please, my lords? He said complaint was given to the vigilance and things
ಅದ್ರ
like
ಮೇಲೆ
that.
ಇಲ್ಲ ನಾವು.
Page number-
Custody ಬದಲಿ mother should get the child.
Please,
Or
my
you
lords.
want argument?
ಇಲ್ಲ, my lords.
ಏನು?
One ನಿಮಿಷ ನೋಡಿ, my lords,
ನೋಡಲ್ಲ
65.
ನಾವು ಆ ರೀತಿ. This is a family matter. Court is the patria, the parent patria. Therefore, I need not go on hearing your jurisprudential argument. I have to see what best interest can be served, or child's interest can be served. That I have to see.
Knows how badly the father has spoken for the lady judge before a petition before this.
ಬಿಡಿ,
honorable
ಅವ್ರ
court.
ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿ, ಅದ್ ಮಾತಾಡಿದ್ರೆ. ಅದ್ ನಂಗೆ ಇದ್ರಲ್ಲಿ ನಂಗೆ ಈ ಕೇಸ್ ನಲ್ಲಿ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಮಾಡಕ್ ಬರ್ತದ? If you have written ill of the judges, judge should take the action. How can that enter decision making in the custody matter?
ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ನೋಡೋಣ.
My lords, how safe is a child in the hands of such a father, please, my lords? If I can give a few citations of the Supreme Court, please, my lords,
ನೋಡೋಣ,
which my
hearing
lords
ಬಂದಾಗ.
have also.
ಈಗ ಮಗು ಬೇಕು ಅಥವಾ ಬೇಡ?
ಖಂಡಿತ ಬೇಕು, my lords.
ಅಂದ್ಮೇಲೆ
Permanent
ಸುಮ್ಮನೆ
custody.
ನೋಡೋಣಂತೆ.
Please, my
ಅದು ಸುಮ್ಮನೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಸಿಗೋದು ಸಿಗದಂಗ ಆಗತ್ತೆ ಮಗುಗೆ, ತಾಯಿಗೆ. ನಾವು ಹೇಳ್ತಾ ಇದ್ದೇವೆ, ಸ್ವಲ್ಪ ಅಡ್ವೊಕೇಟ್ಸ್ ಆದವ್ರೆ ಸ್ವಲ್ಪ ಇಂಥ ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಯಾವ್ದೋ ಸೈಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ದಂಗ್ ಮಾಡೋದಲ್ಲ. ತಂದೆ ತಾಯಿಯ ಭಾವನೆ, ಮಗುನ ಸೆನ್ಸಿಟಿವಿಟೀಸು, ಏನ್ ಮಾಡಿದ್ರೆ ಮಗುನ ಇಂಟ್ರೆಸ್ಟ್ ಪ್ರೊಟೆಕ್ಟ್ ಆಗ್ತದೆ. ಮಗು ಇಲ್ದಂಗೆ ತಾಯಿ ಇದ್ದಾಳೆ, how much suffering she undergoes because
ma'am.
child is away. These things should be kept in our view.
Yes.
Here, child should act as the mother. The court should act as the mother.
True, my lords.
Not court deciding ಹಿಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ.
Thank you.
ಹೇಗೆ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಕೊಡಿ ನಿಮ್ಮ ಒಂದು ಕ್ಲೈಂಟ್.
She's-
When the child is coming back?
She will affirm it, 10th May.
When child is coming back?
On 10th May evening, my lords. That is how they have planned it.
Where is your itinerary of the
I will ask that also.
tour itinerary?
Please, ಅದು ಕೊಡ್ತೀನಿ. Now lower court ನಲ್ಲಿ ಫೈಲ್ ಮಾಡಿದ್ವಿ, ಇಲ್ಲೂ ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ. Full itinerary ಕೊಟ್ಟಿದ್ದೀವಿ.
Deliberately ತಾಯಿನ, you are not supposed to keep the child out of the view of the mother. Though out of the custody of the mother we can understand.
She has
The
met-
mother should, otherwise she undergoes tremendous trauma.
Last Sunday
She
also.
is a mother.
Last Sunday also
Oh,
she has
no, my
met the
lords.
child in the
ಇಲ್ಲ,
morning.
my lords.
ಹತ್ರ ಏನು ಸ್ಟಾಪ್ ಮಾಡಿಲ್ಲ.
My lords.
But there was an attempt to take her
ಜೊತೆಗೂ
away from
ಇದಕ್ಕೆ
the,
ಬಿಡೋದಿಲ್ಲ, my lords.
to
She is
take-
here before the court.
to
my
take her
lords.
away,
ಇಲ್ಲೇ ತರಿಸ್ಬಿಡ್ತೇವೆ ಮಗುನ.
Please, my lords.
to take her away from the fire exit. That is when we complained to the honorable trial court.
ಇದೆಲ್ಲ ಸುಳ್ಳು, my lords.
ಮದರ್ಲಿ ಇನ್ಸ್ಟಿಂಕ್ಟ್ ಇರ್ತದೆ. ನಿಮ್ ತಾಯಿ ನಿಮಗ್ ಮುದ್ದು ಮಾಡ್ತಿದ್ರ ಇಲ್ಲ?
ಈಗಲೂ ಬಹಳ ಮುದ್ದು
ಹಂಗ್
ಮಾಡ್ತಾರೆ
ಮಗುಗೆ ಮದ್ದು ಮಾಡಿಸೋಳು ಹಕ್ಕಿದೆ.
ಸ್ವಾಮಿ.
ಬರೇ ತಂದೆಗೆ ಆಗಲ್ಲ ಪ್ರೀತ್ ಮಾಡ್ಲಿಕ್ಕೆ.
ತಂದೆ ವಿರುದ್ಧ ಮಾಡಬಾರ್ದು.
ತಾಯಿ ಮೈ ಜೊತೆ ಅದು ಆ ಬಿಸಿ ಜೊತೆ
ಆಧಾರ್
ಇರ್ಬೇಕು.
ಕಾರ್ಡ್, my lords.
ಕೊಡಿ. ಯಾವ್ದು ಆಧಾರ್ ಕಾರ್ಡ್?
Aadhaar card for date of birth.
ಡೇಟ್ ಆಫ್ ಬರ್ತ್
And tell-
ನೋಡಿ. do you affirm the date of birth?
Yes.
Date of birth is
Yes,
same. Where is the child now?
At the moment, Port Blair, under
Port Blair.
Yes.
ಏನಮ್ಮ?
Nothing has been given, my lords.
We have submitted in our written arguments.
To the court.
Yes, to the
ಕೊಟ್ಟಿಲ್ಲ,
trial
my
court. ಇಲ್ಲೂ
Yeah.
ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ.
Huh?
ಇಲ್ಲೂ ಕೊಡ್ತೀವಿ.
When they are coming back?
I have been informed 10th is the entire tour, my lords.
Huh.
ಈಗ full itinerary is there. I will ask him to send it again to this honorable court.
Nothing has been submitted, my lords.
Ask him to send the
Not even
itinerary.
tickets, itinerary, ಏನೂ ಇಲ್ಲ.
Complete itinerary is given in written argument 63. Go out and call him and tell him to send it. Yes. Right now I'll get it. Because this is a disposed of matter.
ಇರ್ಲಿ, ಇದು ಡಿಸ್ಪೋಸಲ್ ಅನ್ನೋದು ಇಲ್ಲೇ ಇಲ್ಲ.
correct.
ಇದೆಲ್ಲ ambulatory ಇವೆಲ್ಲ.
Correct.
No disposal.
She
ಮಗುನ ಆ
likes,
ರೀತಿ ತಗೊಂಡವ್ರ ತಾಯಿ ಏನ್ ಅನ್ಕೋಬೇಕು?
she likes all the beach places. That's why the itinerary.
Sale, she likes
Even the
mother
mother
also.
can take.
Definitely,
What beach will mean without a mother
definitely.
to a child?
But father will be able to get into snorkeling with the child.
Huh?
And the mother will do it.
Mother may not be able to.
Why not?
That is the only difference. Some,
Kumata na bhavati.
some physical.
This is what Adi Shankara said. There can be bad son, bad child, but not bad mother.
Absolutely.
Kumata na bhavati.
Absolutely.
ಮತ್ತೆ?
Mark Twain borrowed it and did it for student teachers.
No, no, no. that was- When it went to Port Blair?
On intervening night of 9th and 10th, vacation started.
9th and 10th of
Early morning flight, my lords.
month ಹೇಳ್ರಿ.
April, this month.
9th and 10th.
Because the cheapest tickets were available at that time, my lords. Otherwise, it would have become almost 1.35 lakhs costlier. And she met on the Sunday previous to that. We had 2 days of interim custody in the mall. She met the child.
ಮೆಟ್ಟ ಹಂಗ ಮಾತಾಡಿ ಹೊಂಟ್ಬಿಟ್ಟು.
Yes, ಎಲ್ಲ
ಮಗು ಜೊತೆ ಇರೋದು ಬೇಡ. ತಾಯಿ
ಇಲ್ಲ, ಇಲ್ಲ ಸ್ವಾಮಿ.
ತಾಯಿ ಬಿಸಿ ಅಪ್ಪುಗೆ ಅವಳ ಪ್ರೀತಿ.
ಅವ್ರು ಹೇಳಿದ್ಕೆ ಅವ್ರ ಇಂಟ್ರಾಕ್ಷನ್ ಇಸ್ ದೇರ್. ನಾವು ಎಂದೂ ಸ್ಟಾಪ್ ಮಾಡಿಲ್ಲ. ಬಟ್ ಫಾದರ್ ಇಂದ ಹೆಸರೇ ತೆಗ್ದಾಕ್ಬಿಟ್ಟಿದ್ರು ಆ ಸ್ಕೂಲ್ ನಲ್ಲಿ. ಅವಾಗೆ ನಾವು ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಈಗ ನಾವು ಅವ್ರ ಹೆಸರು ಕೊಟ್ಟಿದೀವಿ, PTM ಎಲ್ಲ ಗೊತ್ತು, ವಿಬ್ಕ್ಯೂರ್ ಸ್ಕೂಲ್ ಗೊತ್ತು, ಎಲ್ಲ ಗೊತ್ತು. ವಿ ಆರ್ ನಾಟ್ ರಿಸ್ಟ್ರಿಕ್ಟಿಂಗ್ ಎನಿಥಿಂಗ್. ದಟ್ ಇಸ್
ಮೋಸ್ಟ್ಲಿ ನೀವು ಪಟ್ರೇಚರ್ ಓದಂಗ್ ಕಾಣದೇ ಇಲ್ಲಲ್ರಿ. ಒಂದ್ ಲಿಟರರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲ. ಬ್ರೇಕ್ ಅದ ರೀತಿ ಡಯರಿ ಟೈಪ್. ಜನನೀಯ ಜೋಗುಳ ವೇದದ ಘೋಷ ಕುವೆಂಪು ಹೇಳಿದ್ದು ಗೊತ್ತಾ? ಅವನ್ನೆಲ್ಲ ಓದ್ಕೋಬೇಕು. ಏನ್ 2 ಸೆಕ್ಷನ್ ಓದಿ ಹಿಂಗಿರ್ತದ ಅನ್ನೋದು ಓದೋದು ಮ್ಯಾಟ್ರಸ್ ಅನ್. ಜನನೀಯ ಜೋಗುಳ ವೇದದ ಘೋಷ. ತಾಯಿಯ ಹಾಡು ವೇದ ಘೋಷ ಆಗಿ ಕಾಣ್ತದಂತ ಮಗುಗೆ. ಕುವೆಂಪು ಹೇಳಿದಾರೆ ಇದನ್ನ. ಹಂಗಾಗಿ ಅಂದ್ರೆ he is highlighting how much important it is that child should spend time with the mother. ಅದು ಬೇಕು ಆರ್ಗ್ಯುಮೆಂಟ್. 2 ಸೆಕ್ಷನ್ ಬರೀ ಇಂಗ್ಲಿಷ್ ಏನಿದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಲ್ಲಿ? ಇಬ್ರದ್ದು ಹಂಗೆ ಇದೆ.
Hello, my lords. My lords has said the same thing in one of your judgments also, my lords.
ಅದಾಯ್ತು. ಇದೆಲ್ಲ ಹೇಳಿದ್ರಿ ಈಗ ನಾ ಹೇಳಿದ್ಮೇಲೆ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಅಲ್ಲ.
My lords, ನಾನು ಇದನ್ನ ಫಸ್ಟೇ ಕೊಟ್ಟೆ, my lords. We have actually we are deciding and demanding only on that piece, my lords.
All right.
Because now the child is a girl child, my lords, getting in the stage of
I have read
womanhood.
the papers. I have not come from Gitter Garden. I also have a daughter. I have seen hundreds of such matters. But their mother is here. We are making some observation favorable to mother. Please. And you are speaking all these things. And he goes on telling section and English other things. ಅದರಿಂದ ಆಗಲ್ಲ.
ನಾನು ಈಗ ಕನ್ನಡ ಓದದ್ ಬರೆಯೋದ್ ಕಲಿತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
ಕಲಿಬೇಕು ಅವನ್ನೆಲ್ಲ.
ಅದಕ್ಕೆ ಸ್ವಾಮಿ.
ಅದರ್ವೈಸ್ ಹೆಂಗ್ ತಿಳಿಯೋದು? ನಮ್ಮ ಕಲ್ಚರ್ ನಲ್ಲಿ ಮಗು ಬೆಳೆದು ಬಂದಿರ್ತದೆ.
ನಾನು ಎಂದು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಓದಿರ್ಲಿಲ್ಲ.
ಇರ್ಲಿ, ಅದು ಬೆಂಗಳೂರಾಗಲ್ಲ, ಯಾವ ಊರಾಗಿದ್ರು ತಿಳ್ಕೊಬೇಕು. ಯಾವ ಇದು ಲ್ಯಾಂಗ್ವೇಜ್
ಓದಿದ್ದೆಲ್ಲ ಲಂಡನ್ ಅಂಡ್ ಬಾಂಬೆ.
ಅಲ್ಲೇ ಸಮಸ್ಯೆ ಆಗಿತ್ತು ನಮಗೆ. ನಮ್ಮ ನೆಲದ ಜನ ಇಲ್ಲ ಅಂದಾಗನೇ ಅವ್ರಿಗೆ ಅರ್ಥ ಆಗ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ.
ಇಟ್ಸ್ ಕಮ್ ಸ್ವಾಮಿ. ನಾವು ಪ್ರಿಂಟ್ ತಗೊಂಡು ಈಗಲೇ ಕೊಡ್ಲಾ? ಇದೇ ಸಬ್ಮಿಟ್ ಮಾಡಿದೀವಿ. ಲಾಸ್ಟ್ 3 ಪ್ಯಾರಾಸ್ ನಲ್ಲಿ ಎಲ್ಲ ಐಟಿನರಿ ಕೊಟ್ಟಿದೀವಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಂದು.
ಬರೀ ಹೇಳಿದ್ದಾರೆ, my lords. ಯಾವುದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಅದು ಕೊಟ್ಟಿದ್ದೀವಿ ಸ್ವಾಮಿ. ವಿ ಹ್ಯಾವ್ ಗಿವನ್ ದಟ್ ಆಲ್ಸೋ.
No copies have come to anybody, my lords.
ಆಮೇಲೆ 11th ಇಂದ ಇಂಟರಿಮ್ ಕಸ್ಟಡಿ ಮದರ್ಸ್ ಗೆ ಮಾಡಿ ಅಂತ ನಾವು ಒಪ್ಕೊಂಡಿದೀವಿ.
ಇಲ್ಲಿ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜೂನ್ ಅಂತ ಹೇಳಿದಾರೆ ಅವರು.
ಹೌದು ಸ್ವಾಮಿ, ನಾನು ಕನ್ಫರ್ಮ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. 4 ಜೂನ್ಗೆ ಸ್ಕೂಲ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ.
4th ಜೂನ್.
Okay, Swami. All right, we will make it happen, whatever your lordships.
1st of May ಬರ್ಲಿ. 1st of May ಗೆ ಮೊದಲಿಗೆ ಕೊಡಿ. ತಾಯಿ, if you read Sigmund Freud, ಅವನ್ನೆಲ್ಲ ಓದ್ಕೊಂಬರ್ರಿ. Sigmund Freud, Carl Gustav Jung, ಎಸ್ಪೆಷಲಿ ಮದರ್ ಅದು ಬೇಬಿ ಇಸ್ ಅ ಗರ್ಲ್ ಚೈಲ್ಡ್.
Yes.
ಮತ್ತ ಆ ಗರ್ಲ್ ಚೈಲ್ಡ್ ಬರೇ ತಂದೆ ಜೊತೆ ಇದ್ರೆ ಗಂಡಸು ಹೆಂಗ್ ಆಕ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಶುರು ಮಾಡ್ತಾರೆ ಹಂಗ್ ಮಾಡಕ್ ಶುರು ಮಾಡ್ತದೆ. ನಾಳೆ ಮ್ಯಾರೇಜ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಇದೆಲ್ಲ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇದೆ. ತಾಯಿ ಮ್ಯಾನರ್ಸು, ದ ಸೆನ್ಸಿಟಿವಿಟೀಸ್ ಆಫ್ ದ ವುಮನ್, that has to be imbibed by her conduct, not by whispering into ears.
ಮನೆಯಲ್ಲಿ ಹೆಣ್ಮಕ್ಳು ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
ಆ?
ಅವ್ರ ಮನೆಯಲ್ಲೂ ಹೆಣ್ಮಕ್ಳು ಇದ್ದಾರೆ.
ಎಲ್ಲಿ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಮನೆಯಲ್ಲಿ
ತಂದೆ ಮನೆಯಲ್ಲಿ
ಯಾರಿದ್ದಾರೆ?
ಅವ್ರ ತಾಯಿನೇ ಇದ್ದಾರೆ, ಒಂದು ಫುಲ್ ಟೈಮ್ ಗವರ್ನೆನ್ಸ್ ಇದ್ದಾರೆ, ಸಿಸ್ಟರ್ ಇದ್ದಾರೆ, ಅವ್ರ ಮಕ್ಳು ಇದ್ದಾರೆ,
Nobody
ಅವ್ರಿಗೂ
can
ಮದುವೆ
take the
ಆಗಿದೆ,
place of the
ಎಲ್ಲ
mother,
ಜನ
my
ಇದ್ದಾರೆ.
lord.
ಇಟ್ಸ್ ಅ ಗೇಟೆಡ್ ಕಮ್ಯುನಿಟಿ ನಲ್ಲಿ ಬಹಳ
There is no substitute.
ಸಬ್ಸ್ಟಿಟ್ಯೂಟ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಹೆಣ್ಮಕ್ಳು ಇದ್ದಾರೆ ಅಷ್ಟೇ.
Correct.
ನೋಡಿ,
Too much argument is said from both the sides.
Sorry, my lord.
It is highly unavoidable, but they do not understand even when it is told to them. Be that as it may, come down. Admittedly, the child is the girl child and aged 9 years.
9 is
9 years.
9 years. She has puberty in the making.
now this is
Puberty.
disputed, my lords.
Puberty in the making. Why can't you understand English? Yes, she has puberty in the making. That's the sentence which Leslie uses in the word, the child psychology. Yes. The counsel for the respondent husband assures the court that the child will be brought to the portals of the court on first May. ಯಾವತ್ತಿದೆ ಸಿಟ್ಟಿಂಗ್ ನಮ್ದು? ಫಸ್ಟ್ ಮೇನಾ ಫಸ್ಟ್ ಮೇ ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಮೇ, 30th ಸಿಟ್ಟಿಂಗ್ ಯಾವ್ದು?
30th is a holiday, first is a holiday, my lords.
29th is last working. On 29/4/2025 at 10:30 in the 10:30 in the morning and deliver its custody peaceably to the petitioner mother. First off. On that day, what next order should be passed will be decided. First off, your client also will be here.
Yes, my lords.
Petitioner and the respondent, mother, petitioner mother and respondent father of the ward are requested to be personally present before the court on that day. First off, if child is not brought to the court on that day, police assistance may be taken.
I undertake, my lords. My undertaking may be noted. No need.
ಏನಂತ?
That I'll bring the child.
No. Therefore, we have put the warning. ನೀವು ಆ ಪ್ರಕಾರ ಇದ್ಬಿಟ್ರೆ ಆ ಪ್ರಶ್ನೆನೇ ಬರಲ್ಲ.
Now, I'm undertaking. Now, my lords, the trial court is pronouncing the order on 19 that may be kept in appeal.
The
Third additional.
the trial court is requested not to pronounce the judgment stroke order without the leave of this court. Okay.
I leave.
Okay.
The documents for IA number 1 and 2 have not been given to me.
ಅವ್ರಿಗೆ ಕೊಡಿ, copy ಕೊಡಿ.
That is the office objection.
ಕೊಡಿ, one more copy ಕೊಡಿ.
And item number 6 is also ours, my lord.
ಏನು?
Next, 6 is also ours. Connected matter.
6.
Yes.
ಹಾ.
That can
ಕಾಲ್
also.
ಅಲಾಂಗ್ ವಿತ್ ಮಾಡ್ಬಿಡ್ಬೋದು. ಅವ್ರಿಗೆಲ್ಲ ಅಡ್ವೈಸ್ ಮಾಡಬೇಕು. ಇಂಥ ಕೇಸ್ಗಳನ್ನ ಕೇಶವಾನಂದ ಭಾರತಿನೂ ಮಾಡಬಾರ್ದು, BDA ಸೈಟ್ ಕೇಸು ಮಾಡಬಾರ್ದು.
Item number 6.
ಹೃದಯದ ಪ್ರಶ್ನೆ.
Item
ಮಗು
number
ಇದು.
Yeah, item number 6, I have a grievance, my lord. That is a family court matter of the MC case. The honorable trial court has made a reference to you under section 113.
ಮ್ಯಾಲಿನ್ ಸೆಂಟೆನ್ಸ್ ಹೊಡೆದಾಗ don't write.
Yes, under section 113, but your lordship had directed the registry to give us a copy of that reference letter. Unfortunately, my lords, this is the
ಅದು
time.
ಕೊಡ್ರಿ, ಇಲ್ಲಿದೆ ಏನ್ರಿ ಅದು ಲೆಟರ್? ನೋಡಿ ಬರ್ರಿ, ವಾಟ್ಸ್ಆಪ್ ತಗೊಳ್ರಿ, ಒಂದು ಫೋಟೋ ಬರ್ಕೊಡ್ರಿ. The petitioner, the respondent husband is permitted to take a WhatsApp photograph of the letter dated.
My lords,
ಬರ್ಕೊಳ್ಳಿ.
it is not there in the file now.
ತಗೊಂಡಿದ್ದಾರೆ, my lords.
It is not there in the file.
My lords, that's a letter written by the judicial officer.
Why you are worried about that? This court wants to share it with him.
My lords,
You appear to be troublemaker, but I do not know. You appear to be that way. Court wants to give a letter to him.
please,
If you want, you will give 2 more letters to you.
please, my
How
lords.
can you object to that one?
I'm
Then
not
the
objecting, my
registry-
lords.
ಏನು Official Secrets Act ಇದೆಯಾ?
The registry says now the annexures are missing, my lords. because we had asked for both and this is the quality of the letter which has been given to us.
ಓದಕ್ ಬರ್ತದ?
ಆಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಯಾಕೆ ಆಗ್ತಾ ಇಲ್ಲ? ಅಷ್ಟೇ ಜಾಗದಲ್ಲಿ ಕೊಡಿ.
Every page ನಲ್ಲಿ ಹಿಂಗಿದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲ ಪೇಜ್ ನಲ್ಲಿ ಓದಕ್ ಬರ್ತದ. ಸ್ವಲ್ಪ ಅದನ್ನ ಲೆನ್ಸ್ ಇಟ್ಕೊಂಡು ಕೊಡಿ.
Annexures miss ಆಗ್ತಾ ಇದೆ.
ಮನಸ್ಸಿಲ್ಲ ಅಂದ್ರೆ ಓದಕ್ಕಾಗಲ್ಲ, ನಮ್ಮ ಮನಸ್ಸಿದ್ರೆ ಓದಕ್ಕಾಗಲ್ಲ. ಕೊಡಿ ನೋಡಿ.
ಅದು ಸ್ವಲ್ಪ ಒರಿಜಿನಲ್ ನೋಡ್ಬಿಡಿ ಸ್ವಾಮಿ.
ಅವ್ರು ಇಲ್ದ ಕೋರ್ಟ್ನಾಗ ಇಲ್ದ ಬರಪ್ಪ ಒಂದ್ ನಿಮಿಷ ಬನ್ನಿ. ಯುವರ್ ಸೆಲ್ಫ್ ಕಮ್.
ಆಮೇಲೆ annexures are missing ಸ್ವಾಮಿ.
Don't jump on to others. First, you said it is not readable. ಇದು ನಿಮ್ಗೆ ಓದ್ಲಿಕ್ಕೆ ಬರುತ್ತೆ ಇಲ್ಲಿ ನೋಡಿ, ಕೊಡ್ರಿ. ಏನು ಇಡೀ ಫ್ಯಾಮಿಲಿ ಲಾ is Ramesh. You know why family law is being hijacked by the niceties of advocacy. ನೀವಿಬ್ರು both you should read. ಬಿಡ್ರಿ ಅಂತ ಹೋಗ್ಕೊಳ್ಳಿ ಭಿನ್ನಾಭಿಪ್ರಾಯ ಇಲ್ಲ, ತಂದೆಗೆ ಮಗುನ್ ಜೊತೆ ಭಿನ್ನಾಭಿಪ್ರಾಯ ಬಿಡಿ, ನೀವಿಬ್ಬರು ದೂರಿಡಿ. ಮಗು ಯಾಕೆ ಹರೆಸ್ ಆಗ್ಬೇಕಪ್ಪ? ಮಗು ತಾಯಿ ಪ್ರೀತಿ ಬೇಕು, ತಂದೆ ಪ್ರೀತಿ ವಾತ್ಸಲ್ಯ ಬೇಕು ಅಲ್ವಾ? ತಾಯಿ ವಾತ್ಸಲ್ಯ, ತಂದೆ ಪ್ರೀತಿ ಎಲ್ಲ ಬೇಕಾಗತ್ತೆ, ಎಸ್ಪೆಷಲಿ ಗರ್ಲ್ ಚೈಲ್ಡ್. ಅದು ಇಟ್ ಶುಡ್ ಆಲ್ವೇಸ್ ಸ್ಪೆಂಡ್ ಟೈಮ್ ನಾಟ್ ವಿತ್ ದ ಮದರ್. ಯು ಸೇ ದಟ್ ದೇರ್ ಆರ್ ಮೆನಿ ಪೀಪಲ್, ಒಂದು ಇಂಗ್ಲಿಷ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ದೇರ್ ಆರ್ ಮೆನಿ ಪೀಪಲ್ ಇನ್ ಅವರ್ ದಿಸ್ ಒನ್ ಅಂತ, ದಟ್ ಈಸ್ ನೋ ಆನ್ಸರ್ ಅಂತ ಹೇಳ್ತಾನೆ ಒಬ್ಬ ಇಂಗ್ಲಿಷ್ ಜಡ್ಜ್. ಅದನ್ನೆಲ್ಲ ಓದ್ಕೋಬೇಕು, ಅವಾಗ ಲಾಕ್ ಅರ್ಥ ಬರ್ತದೆ. ಇಲ್ಲ ಡೆಡ್ ಲೆಟರ್ ಇದು, ಈಗ ನೀವು ಮಾಡಿರ್ಲಿ ಇಬ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಹಂಗಾಗ್ತದೆ, ಅದರಿಂದ ಬರಲ್ಲ. ಅಟ್ ಲೀಸ್ಟ್ ಫ್ಯಾಮಿಲಿ ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಏನ್ ಹೇಳ್ತದೆ, ನಮ್ಮ ಲಿಟ್ರೇಚರ್ ಏನ್ ಹೇಳ್ತದೆ, ಸೈನ್ಸ್ ಏನ್ ಹೇಳ್ತದೆ, ಗ್ರೇಟ್ ಫಿಲಾಸಫರ್ಸ್ ಏನ್ ಹೇಳ್ಯಾರೆ, ಮದರ್ ಮ್ಯಾಕ್ಸಿಮ್ ಗೊರ್ಕಿ ಅವನು ಏನ್ ಹೇಳ್ತಾನೆ, ಅವಾಗ ಮೀನಿಂಗ್ ಬರ್ತದೆ ಲಾಕ್. ಎಲ್ಲ ಎರಡು ಸೆಕ್ಷನ್ ಓದೋದು, ಈ ಕಾನ್ವೆಂಟ್ ಇಂಗ್ಲಿಷ್ ಮಾತಾಡೋದು ಹೋಗೋದು. ಎಸ್,
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಓದಕ್ ಬರ್ತದೆ ಅಲ್ವ? ಓದಕ್ ಬರ್ತದೆ ತಾನೆ, ನೋಡಕ್ ಬರತ್ ನೋಡಿ, ಓದ್ಕೊಳ್ಳಿ ತೊಳಿ, ಅಥವಾ ಇನ್ನೊಂದ್ಸರಿ ನಿಮ್ಗೆ ಇದು ಮಾಡ್ಕೊಂಡು ಅಷ್ಟೆಲ್ಲ ಟೆಕ್ನಿಕಾಲಿಟೀಸ್ ಮೇಲೆ.
annexures ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ, ಇಟ್ ಇಸ್ ಮಿಸ್ಸಿಂಗ್ ಅಂತೆ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಅನೆಕ್ಸರ್ ಇಲ್ಲ ನಮ್ಮ
ಅದ್ರಲ್ಲಿ ಇಲ್ವೇ ಇಲ್ಲ.
ಇದರಲ್ಲಿ ಇದೆಯಾ? ನಮ್ಮ ರೆಕಾರ್ಡ್ ಇದರಲ್ಲಿ ಅನೆಕ್ಸರ್ ಮಾಡಿದ್ದಾರೆ?
ಅದ್ರಲ್ಲೂ ಇಲ್ಲ ಸ್ವಾಮಿ. ಬಟ್
ಯು ಆರ್ ನಾಟ್ ಮೈ ಕೋರ್ಟ್ ಆಫೀಸರ್,
ಐ ಆಮ್ ಸಾರಿ,
though you are an officer of the court. Yes. Annexers ಇದೆಯಲ್ಲ?
My lords, we have only sought a direction to see that letter written by the thing, because there are two divorces, my lords. One filed by the mother in 2017 in West Bengal, but that has been hidden. And another divorce has been filed by the father here, my lords, in 2021.
Huh?
So when the family court came to know about it, the judge has written to the High Court, my lords, seeking instructions on that. There are two divorces, nan yen madli anta.
ನೋಡೋಣ, ಅದನ್ನ ಮೊದ್ಲಿಗೆ ಈ ಚೈಲ್ಡ್ ಬಗ್ಗೆ ನೋಡೋಣ ಅಂತ, ಮುಂದೆ
ಆಯ್ತು my lords.
ಏನ್ ಮಾಡಬೇಕು ಅಂತ ನೋಡೋಣ ಅಂತ. ಇದ್ರ ಜೊತೆ ಅನೆಕ್ಸರ್ಸ್ ಯಾವ್ದಾವ್ದು ಇದೆ ಇದ್ರಲ್ಲಿ? ನಿಮ್ಮ ಅನೆಕ್ಸರ್ಸ್ ಏನೇನಿದೆ?
ಅವ್ರ ಪ್ರಕಾರ ಸ್ವಾಮಿ, ಲೆಟರ್ ಪ್ರಕಾರನೇ ಒಂದು 17 annexures ಇದೆ, annexure A, B, C ಅಂತ.
ನನಗೆ ಅದು ಯಾವ್ದು
ಅದನ್ನೇ ಇಲ್ಲ, ಇವ್ರ ಲೆಟರ್ ಅಲ್ಲ, ಸಾಹೇಬ್ರು ಬರ್ದಿರೋದು, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಸಾಹೇಬ್ರು. ಅದಕ್ಕೆ ಇದ್ರಲ್ಲಿ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಯಾ annexures ಏನ್ ಸ್ವಾಮಿ, ಬಿಕಾಸ್ ಅಲ್ಲೇ ಬ್ಲಾಕ್ ಮಾರ್ಕ್ ಬಂದಿದೆ. ಅಕಾರ್ಡಿಂಗ್ ಟು ದ ಲೆಟರ್ ನಾನು A, B, C ನೋಡ್ಬೋದು.
ಅವ್ರ ಚೈಲ್ಡ್ ಕರ್ಕೊಂಬನ್ನಿ ನೋಡೋಣ. ವಿಲ್ ಅಡ್ರೆಸ್ ದಟ್ ಆಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್. ಅವ್ರು ಸಿಗ್ನಲ್ ಹಾಕ್ಲಿಕ್ಕೆ ಹೇಳ್ಬೇಕು. ಹೌದು, ಆ ದಿವಸ ಅದೊಂದು ಫೋನ್ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಹಾಕೊಳ್ಬೋದಾ ಅವತ್ತು?
ಪ್ಲೀಸ್ my lords.
ನಿಮ್ಗೆ ಅನುಕೂಲ ಆಗ್ತದಾ?
ಈ ಟೈಮ್ my lords.
ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಹಾಕೊಂಬಿಡಿ, 1 o'clock ಹಾಕೊಂಬಿಡಿ. ಓನ್ಲಿ ಒಂದು ಮ್ಯಾಟರ್, ಅದು ಚೈಲ್ಡ್ ಕಸ್ಟಡಿ ಅಲ್ಲ, ಮುಗಿಸ್ಬಿಡ್ಬೋದು. ಇಲ್ಲಪ್ಪ ಚೈಲ್ಡ್ ಸಫರ್ ಆಗ್ತದೆ ಇವ್ರ ಎಡೋಕಸಿಯಲ್ಲಿ, ಅದಕ್ಕೆ. ಎಸ್
My lords, 29th at 1 o'clock, my lords.
1 o'clock.
Grateful, my lords.
Obliged.
Yes. 4. ಏನಿದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಟೈಮ್ ಎಷ್ಟು ಕೇಳಿದ್ದಾರೆ ಕಾಣಿಸಲ್ಲ 6 months granted. Extension of 6 months granted in terms of letter dated 16/12/2023 with a warning that no further time will be sought for. Shall be sought for. Yes. Same. Swami.
I appear for the response in the above case.
Yes, Mr. Saukar, ಏನಿದು?
The arbitration award was passed, madam. Against that arbitration award, the petitioner went in appeal to the civil court. There it is dismissed on a condonation of delay.
Okay.
Application. Against that, they have preferred also the MFA. In MFA, the matter was remanded back to the trial court. Against which MFA matter we have preferred a SLP before the Supreme Court. Supreme Court has allowed our petition and also set aside the order of the MFA also.
MFA order is set aside.
Yes, yes, it has been set aside. There is no question of, since the petition filed before the civil court arbitration suit is beyond the time, more than 9 months. So it did not, the MFA was also remanded against that manner. Against that, we prepared an appeal to the Supreme Court.
You said that. Where is that order of the apex court?
We have produced, madam. I have produced in my IA also at page 25. I have produced that order. Annexure R2 at page 25, the order of the Supreme Court.
Review ಯಾರು ಹಾಕಿದ್ದಾರೆ ಇದನ್ನ?
ನಾವು ಹಾಕಿದ್ದೀವಿ.
ಅವರೇನ ಹಾಕಿದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, but there is no, this thing is. ಏನು ನಮ್ಮಲ್ಲಿ ಏನು, I have searched all throughout, but I didn't find anything with regard to that. They have been saying for the last so many months.
Review petition filed before what court? Which court? Apex court?
Apex court ನಲ್ಲೇ
ಸಮಯ ತೋರಿಸಿ. ಅಕ್ನಾಲ್ಮೆಂಟ್ ಅವ್ರಿಗೆ ಹಾಕಿರೋದನ್ನ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ, ಹೌದು ಸರಿ ಮಾಡಿದ್ದೀನಿ.
ನಿಮ್ದು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಎಲ್ಲಿದೆ ತೋರಿಸಿ.
ಹಾಕಿದ್ದೀನಿ ಸರ್, ಕೊಟ್ಟಿದ್ದೀನಿ.
ಅದು ಎಷ್ಟು ಒಂದು ವರ್ಷದ ಮೇಲೆ ನಾವು
ಒಂದ್ ನಿಮಿಷ
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಹೈಕೋರ್ಟ್ ಆತು ಅಲ್ಲಿ ನೀವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನಲ್ಲಿ ರಿವ್ಯೂ ಹಾಕಿರಾ? ಎಲ್ಲಿದೆ ಕೊಡಿ.
ಕೋರ್ಟ್ಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
ನಿಮ್ಮತ್ತಿಗೆ ಇರೋ ತೋರಿಸಿ.
ನಮ್ಮ ಹತ್ರ ಈ ಕಾಪಿ ಅನುಭವ ಕೊಟ್ಟು ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ ಸ್ವಾಮಿ, ಸರ್ವ್ ಮಾಡಿ ಅಕ್ನಾಲ್ಮೆಂಟ್ ಮತ್ತು ನೋಟಿಸ್ ಕೂಡ ಹೋಗಿತ್ತು.
ಅದ್ರಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಹ್ಞೂ ಸ್ವಾಮಿ, ನೋಟಿಸ್ ಆಗಿದೆ. ನಾನು ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ, ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ. RPD ಮಾಡ್ಬಿಟ್ಟು ಮತ್ತೆ ಅಕ್ನಾಲ್ಮೆಂಟ್ ಎಲ್ಲ ಕೊಟ್ಟು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಸರ್.
ನಮ್ಮ ಪ್ರಶ್ನೆ ಸರಿಯಾಗಿ ಅರ್ಥ ಮಾಡಿಕೊಂಡು ಉತ್ತರ ಕೊಡಬೇಕು. ನೀವು ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪರಿಶೀಲನಾ ಅರ್ಜಿ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ.
ನಂಬರ್ ಎಲ್ಲಿದೆ?
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, ಕೊಟ್ಟಿದ್ದೀನಿ. ಪ್ರೀವಿಯಸ್ ಡೇಟ್ನಾಗ ಕೊಟ್ಟಿದ್ದೆ ಸ್ವಾಮಿ, ಮತ್ತೆ ಈ ಡೇಟ್ನಾಗೂ ನಾನು ಕೊಟ್ಟಿದ್ದೆ. ಲಾಸ್ಟ್ ಡೇಟ್ನಾಗ ಅನುಭವ ಕೊಟ್ಟು ಮತ್ತೆ ಕೊಡಿ ಅಂತು, ಮತ್ತೆ ಇವ್ರು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಅವ್ರಿಗೆ RPD ರಿಜಿಸ್ಟರ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ ಸ್ವಾಮಿ, ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಅಕ್ನಾಲ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ.
ನಾವು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಇದೆನಾ ಅದು ಮ್ಯಾಟ್ರು?
Execution is also. Now they also deposit the amount in the court also.
Mr. Saukar.
The execution is almost concluded. At that stage, the writ petition has been filed.
ನೀವು ಬನ್ನಿ ಪರ್ಸನಲಿ ಬನ್ನಿ ಕೇಸ್ ನಡೆಸೋಣಂತೆ. ಇಲ್ಲ ಕಮ್ಯುನಿಕೇಶನ್ ಆಗ್ತಾ ಇಲ್ಲ ತಳಿ. Post when it's a single. Next. Next. Entry more to continue. Yes, next. ಏನು
the writ dispose ಆಗಿತ್ತು thereafter lord being spoken as mood saying that lord 29(2) ಕೆಳಗಡೆ ಕೊಡಕ್ಕೆ ನೀವು ಆರ್ಡರ್ ಮಾಡಿ ಅಂತ, but your lordship lord did not consider. Thereafter IA is filed lord for the same prayer that lord to pay the compensation for the Karab land under 29(2) ಅಂತ ಹೇಳಿ.
Karab land. A Karab B Karab.
A Karab. Lord, it's Bande. Bande it is lord.
A Karab under rule 20 belongs to the owner only.
That is correct, my lord. That has been, my lord, your lordship dealt with, my lord, all them that, and my lord, thereafter, my lord, award is, my lord, LAC proceedings, my lord, is pending. That is challenged by, my lord, the petitioner before, my lord, this court. It is pending, my lord, in writ petition number 23, 25337 of 2023.